Justice of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to be before this court may draw near and take attendance to the court.
Thank you. Please be seated. The first case out for argument today is case 906, People v. Everett. Counsel, proceed.
Good morning, Your Honors. May it please the Court, Axel Lecomte for the appellant, Mr. Eric Everett. I will just address point 1 of my brief. One of the main challenges for a public defender is to get your client to trust you. We have to show them that we are real lawyers and that we are on their side. And we have to do that because they have the constitutional rights to receive meaningful representation.
Counsel, let me ask you this, and you correct me if I've got this wrong. You know the record no doubt better than all of us. But in this particular case, counsel was confronted with kind of a, well, I won't say it's an unusual situation, but he had a client that he felt didn't understand aspects of the law or misunderstood aspects of the law and thought he had essentially a get-out-of-jail-free card. He thought he could not be convicted. And there was a plea offer on the table, and counsel was concerned that his client, who he had consulted with on this, was not understanding, his communications with the client were failing, right? And the client was adamant that he knew what was going on here, and he was convinced that he could not be convicted. That's an incredibly difficult position for an attorney to be, and you'd agree with that, right?
Yes, I do agree that it is a difficult situation, but I do believe that
if the lawyer did nothing under those circumstances and simply let the plea go forward, wouldn't you be here arguing that the lawyer needed to do something and could not let his client go forward with the plea with a mistaken understanding of the law?
So I believe that part of meaningful representation is the advice that the lawyer has to give to his client. And I do believe that it is important that your client does receive the legal advice and maybe tell them when their legal theory might not be the ones that the lawyer wants to advance. But I think here, this is not really what is at issue. I think here what's at issue is a disclosure of the advice to the judge and to the people. Is
your argument, if this wasn't in camera, which it wasn't, and maybe it would have been appropriate to have it, but if this wasn't in camera, a conversation with just the judge and the defendant and the lawyer, you wouldn't be making this argument. Is that true?
I think if it was not on the record and if we were not able to look at the record and see exactly what advice defense counsel told Mr. Everett and what his opinion about the plea was, I think, yes, I would not be here in front of you. It would not be on the record. Maybe I would be doing a 440 motion, but yeah, that's true. It would not be the same argument. Because I think really what's at issue here is, again, the disclosure of the advice. I think it is highly...
Your concern is it infected the relationship. It infected the relationship between the defendant and the trial attorney from that point going forward, and that the defendant could no longer trust his lawyer to not disclose to both the judge and who was sitting. This was a non-jury trial, right?
That's correct.
Which is an important consideration on your part, right?
Yeah. Yes, absolutely, absolutely.
And so your concern was it infected the relationship. They no longer had the ability to communicate with each other in an effective way in preparation for and during the term of this trial, and that as a result it was ineffective.
That's correct, Your Honor. I think there is two highly prejudicial things here. First, that's exactly what Your Honor described. It did have a really big impact on the relationship. I think that the attorney-client privilege is at the core of the right to counsel, and it was ruled in People versus Roselle that defense counsel was ineffective when he disclosed confidential information to the judge. I think this case applies here. So it did have an impact on their relationship. It could not go to trial with lawyers that he could not trust. I think it could not go to trial with lawyers that he knew could say things to the judge, to the trier of fact. It was a bench trial, but I think it also had an impact on the trial itself, because I think that the position that defense counsel took many times was, he was hinting at his client's guilt. And I think this is highly prejudicial, and I think this is, it did diminish the presumption of innocence here. I do believe that, especially because, as you said, it was a bench trial, so it was the same trial of fact. And also, in addition of the disclosure, there was also adverse position, and I think that's another point that makes it ineffective here. I think defense lawyer crossed the line because he didn't have to go and explain to the judge how wrong Mr. Everett was. And I cite in the brief People versus Mitchell, where I think here quite neutral language was already found improper by the Court of Appeals, and I think in Mr. Everett's case we went even beyond that. It was quite neutral in Mitchell to say that defense counsel do not adopt the merit of the motion. And here what happened is that he denigrated his client, saying that his theories were a phantom legal impediment, especially after Mr. Everett told the trial of fact that he wanted to pursue these theories at trial. So I think it was highly prejudicial here.
Anything further?
Just to summarize, I think here what's important is the cumulative effect of all the disclosure and the adverse position and the errors during trials that I addressed in point 1 and 2 and 3, and this cumulative effect did deprive Mr. Everett of his right to a fair
We'll take a
trial.
look at your argument. Thank you, counsel.
Thank you.
Case 907, People versus Cooperman?
Excuse me, Your Honor.
Yes.
I'm the respondent.
Oh, my apologies.
Sorry.
I'm thinking the counsel was appearing solo. My apologies. We'll give you a chance to argue, counsel.
Thank you, Your Honor. Just, I won't take up too much time, but
No. Do not feel rushed over my mistake.
I believe defense counsel has a duty to ensure that his client's decision to accept or reject the plea is informed and knowing. I believe if you look at the record as a whole, it's clear that that's what he was doing. There's no indication that he could not, as a result of it, defendant did not trust him or that they couldn't communicate during the trial. That's pure speculation. And just, I suppose I'll leave it at that unless there's any questions.
No questions, counsel. Thank you, and sorry for the misunderstanding.
No problem. Thank you.
Now we'll go with 907, People versus Cooperman. Counsel, proceed.
Good morning. May it please the court. The people failed to timely establish readiness for trial under CPL 3030 when the people did not provide Office of Emergency Communications materials required for a proper certificate of compliance until more than 9 months after the commencement of this proceeding. These Office of Emergency Communication dispatches and other materials were not provided until May 23rd. There was no dispute in the court below that they were required to be provided, but rather the trial district attorney for months urged that there were no such materials.
Counsel, if we agree with you and say, yeah, they were belatedly provided and the certificate of compliance was obviously filed then without those having been provided in a timely fashion, is the question before us whether the certificate of compliance was filed in good faith and reasonable under the circumstances? Is that the standard that we're looking at this?
Respectfully, there's two different things that have to be shown. One, good faith, and two, due diligence. Because there's no argument that it was bad intent. But there's a requirement in the statute that the people exercise
What is
due
it then
diligence.
under due diligence that the people should have done that they didn't do?
Two things. One, the people directly should have contacted the Office of Emergency Communications because the Office of Emergency in Monroe County, that office is a separate agency from the Arundecoy Police Department. They're the agency that keeps all recordings for all police agencies in Monroe County.
Now, there was no 911 call here, right?
There was no 911 call, but that's not, the statute says including 911 calls, and not just 911 calls. That's number one. Number two, if and when the prosecutor wants to rely on a law enforcement agency, they have to see that law enforcement agency exercise due diligence. But that agency, in this case the Arundecoy Police Department, also did not contact the Office of Emergency Communications. It's important to note that on February 24th, there was a motion prior to the May disclosure, pointing out the failure to provide these materials. That was prior to the running of the 30-30 time. So the DA was on actual notice from the defense attorney about this failure. Despite that February 24th motion, and despite defense counsel saying, I contacted the office, they have materials, please get them to me, the DA did not do so until 2 months later in May, which is, again, after these 30-30 time expired. The people argue in their papers, well, these materials weren't important, they weren't used at trial. That's a prejudice argument. As this court held in People v. Gaskin, prejudice is not a consideration under 30-30. Again, make sure I fully answer your question.
Where do you draw the line, Counselor, on due diligence? I mean, here, the record reflects, if I recall correctly, that the prosecutor made multiple inquiries to an investigator. I think the name was Soprano. And Soprano continued to say, there's nothing there, there's nothing there. That's my general understanding of the record. And so you're saying that the prosecutor then, to have good faith and have due diligence, has to contact every county agency that might have information? How do you draw a line? That's the first question. Where do you draw it? Secondly, do you agree that what we have here is a question of whether or not there was an abuse of discretion under the good faith and due diligence standard?
Let me try to answer. There are a few questions in there. So first of all, I'm not arguing that the people are always can never rely on law enforcement. In this case, they did not repeatedly ask law enforcement, in this case the Arundecoy police officer, did you contact the Office of Emergency Communication? The only request was there a 911 call? And there wasn't. But the statute requires providing more. Indeed, the record shows that the DA's own checklist, which is on page 20 and 21 of the record, includes contact OEC, the Office of Emergency Communications, to see what other materials they had. That could have been done either by the prosecutor or by law enforcement. In this case, it was done by neither, and that's why I drew the line. If you're going to rely on law enforcement, you have to make sure law enforcement did its job. They didn't. If they had asked the law enforcement agency, "Do we have everything under the statute?" It would have been a different case, Your Honor. In this case, they only asked, "Do you have one thing that's required?" The 911 call. With respect to abuse of discretion, I don't believe the standard is abuse of discretion, Your Honor, because abuse of discretion applies when, in fact, there's record support. In this case, there's no record support that, in fact, there was reasonable efforts by the people to obtain the Office of Emergency Communication materials until May, despite being put on active notice in February, despite the obligation existing all along, and as recognized by that office.
But you're not saying they were put on notice that there were these records. You're just...
No, I am.
The defense lawyer contacted the Office of Electronic Communications.
That's correct.
And he was told that...
He was told they were there, and the defense attorney told that both to the court and to the prosecutor. That was in February, and then two months later, the prosecutor, for the first time, contacted them, and lo and behold, the defense attorney was correct. They were there, and that's the problem in this case. This is not a case where they had good faith and due diligence earlier.
So you're relying on the due diligence. They failed to meet the proper standard of due diligence. So does the court have no discretion at that point to say, look, based upon the materials that were not produced and the impact that they would have on the trial, it can be forgiven, and they have discretion to do that?
No, Your Honor. Respectfully, the materials that are required to be provided under Article 245, there's not a prejudice standard. The fact that these materials may not have been important is not a consideration for determining the obligations to people to timely provide the materials. And the statute is clear on the 245-50 that if the people fail to timely provide materials, they cannot be ready for trial. In this case, they were not ready for trial until May 23rd, which is too late.
If we were to decide that the OEC that there was a reasonable belief that the OEC didn't have any records until February, until the statement was made by defense counsel. Would it be inappropriate to have a decision where the court would charge the 30-30 time from February to May to the people, but not time necessarily before that?
I would argue no, because the allegation existed all along, because there was never a request to OEC by either law enforcement or by the people. Again, I'm not saying that in every case the DA's office has to contact OEC, although their own checklist provides that they should do that. But they should, if they're not going to do that, if they're going to rely on law enforcement, then they should ask law enforcement, did you contact the OEC? Again, the Arundel Police Department doesn't keep these records. Everyone in Monroe County, in terms of criminal justice system, knows that. They're the agency that has to be contacted. No one contacted them. If in February they were contacted, they would not have been a 30-30 issue, would have been a 245-80 claim, and probably would have been no prejudice at that point, and therefore nothing would have happened. Is the failure to act even then created a situation where they waited 2 additional months, or more than actually, 2 full months later, and past the 30-30 time, and they finally provided that. One final thing on this point before I move on, I'll try to be quick on this. The people argue, well, there was not a motion with respect to the supplementary certificate. There's a number of problems with this. Again, as we've just been discussing, the problem with the failure to provide this was already brought to the attention of the DA much earlier. That's number one. Number two, until May 9th of 2022, there was no obligation for defense attorneys to advise prosecutors of any failures with respect to discovery. That's when the statute amendments went into effect. By May 9th, it was already too late. And third of all, that argument was not made below, and therefore is not available for this court as a basis for a decision. If I could quickly address, move on to point 2, it's our contention that the guilty verdicts were against the weight of the evidence. The issue at trial was whether or not the sexual encounter between Mr. Cooperman and ND, the complainant, was consensual. ND testified, and on cross-examination, she acknowledged that after having sex with Mr. Cooperman, she continued to live with him.
Is your argument, Mr. Schifrin, that the victim's credibility was entirely worthless, that as a matter of law, that the jury should not have been able to rely upon it? Is that your argument,
No.
or do you agree that it's a question of credibility?
It's I'm not arguing as a matter of law. The jury could have considered that, but this court, of course, has the weight of evidence jurisdiction. I'm arguing that when she finally moved out, the fact that she asked Mr. Cooperman to help move her mattress, the fact that after she moved out, she returned on multiple occasions to use the shower at Mr. Cooperman's residence, including when Mr. Cooperman was present, the fact that she continued to text with him and maintain a social network relationship with him, and it wasn't until after she learned that he was back with his girlfriend, that 3 months after the sexual encounter, that she went to the police. That's all factors that should be considered in determining her credibility, because they're all evidence inconsistent with her allegations. None of those facts are mentioned in the respondent's brief, nor does the respondent's brief mention that her claim that she was carried up the stairs was shown to be pretty much impossible, given the fact that
That's because of the level of the
That was-
ceiling and the height of the stairs and...
Exactly, it was 5'3", and he's 5'9", she's 5'8". It would have been very, very difficult. It's not mentioned in the respondent's brief that she claimed that she had told her friend Emily about that she was forced to have sex, and that she claimed to have shown her bruises to Emily. Emily's called as a witness, and she doesn't say either of those things. And finally, Mr. Cooperman, when twice questioned by police and recorded interviews that were admitted at court, not only did he consistently tell the police these were consensual encounters, but he did so even when the police lied to him and said, well, we have photos of her bruises. He was consistent. What you have here is a he said, she said, where the she said is so inconsistent with her behavior that not to be worth of credit, and the weight of the credible evidence doesn't support the conviction, which explains in part why the jury acquitted of 2 of the counts. If you believed her, there should have been conviction of all the counts. What you have here is a jury clearly troubled, and they had some sort of compromised verdict. It's difficult to explain that verdict otherwise. And my final point is we urge that the imposition of a 3.5-year sentence in PRS after he was acquitted of the 2 highest counts was harsh and excessive and should be reduced. Where pretrial, he was offered shock probation, and the PSR report understandably recommended shock probation, given his record and his exemplary behavior as an EMT.
We'll take a look at that, counsel. Thank you.
Your Honor.
Good morning. Marty McCarthy for the people. Starting with the OEC materials, if you read 24020, it doesn't refer to Office of Communications materials as discoverable. It refers to 911 calls as discoverable.
But doesn't it say 911 calls and other information? It doesn't strictly say 911.
It just says 911 calls. It doesn't relate to, it doesn't say other information.
But it doesn't just say 911 calls, does it?
Is it using 911 calls as an example?
It says including.
But not limited to?
It didn't say but not limited to.
Yeah.
So I believe the.
Well, that certainly it shouldn't be read as only 911 calls.
But in terms of reading more into it, it doesn't say but not limited to 911 calls. It only says 911 calls. And if you're going to construe the statute, I think you have to construe the statute based on the words that are there.
What subsection are we under? 1G?
I believe so, yeah. So,
And that has to do with electronic recordings?
yes.
Okay.
Yes, and in respect to what was ultimately turned over, was in essence a radio call from a car to the center to get a crime report number so they can execute a warrant. That's it. That's all it was. That's why it never comes up again at trial. Nobody uses it at trial because it's a nothing. It's an absolute nothing communication. With respect to the process, the people did file a supplemental certificate of compliance. It was the obligation of the defense attorney to challenge it since the 24550 had been amended prior to the filing.
Let's back up just a second. You've heard counsel's argument, and I want you to focus on and respond to his argument that defense counsel told the prosecutor and the court that there are these records. And they still weren't produced in a timely fashion.
I don't believe he told, and I may be misunderstanding, I don't believe he said what's there. He simply communicated that there were records at OEC.
Isn't that enough notice, especially when you consider the fact that there's a punch sheet that says, get these OEC records?
You have to look at you have to go back to the statute. So if those things were.
What's the purpose of the punch sheet that says, check? Did we check the OEC records?
The OEC records for 911 calls, a 911 call.
For just 911 calls?
Which is what.
Is that what this sheet says? Just 911 calls? Don't check for any other electronic records?
You have to interpret the sheet with respect to the statute. What the statute says is required in terms of automatic discoveries, 911 calls, okay? And our 911 calls in Monroe County are housed at the OEC. That's the only place they are. So in checking with OEC, we're checking for 911 calls. In that scenario, there were no 911 calls because the prosecutor checked with Irondequoit, was there a 911, they're telling me that there's records, was there a 911 call? The officer said no.
So your argument is that there was no obligation to turn these over at all?
Because it's not part of automatic disclosure. They were not in our file. They're not.
You have no obligation?
If they became part of our file, because we obtained them, then yeah, we would, but we didn't obtain them. The only thing we were required, the other thing is, and this came up at the Court of Appeals argument last week on this issue.
So if they were, I just want to understand the process here. If they were sent to you, and they're in the DA's office file, then they're discoverable?
Arguably, yeah, because they're in our file.
Okay. But under the statute, you're not required to...
Because it's not automatic.
Let me finish.
Oh, I'm
So
sorry.
I understand.
I thought you were finished.
Also fine, I understand. And my questions may be a bit confusing, and I apologize for that. But I want to understand the process. So you're saying that if they're in your file, they're discoverable, right? And they need to be turned over. If they're not in your file, and you don't ask for them, then they're not discoverable. That's your position.
I would say the answer to that is yes, and the reason for my answer being that is what's automatically discoverable is a 911 call. So a citizen calling the 911 center to report a crime. If we obtain information that's not automatically discoverable, that's in our file, then I believe it's our obligation to turn it over, not because it's automatically discoverable, but simply because we have the information, we turn it over, based on the free flow of information between the sides.
Mr. McCarthy, again, define for me, I think I know what we're talking about, but specifically from your perspective, what information are we talking about? It's not a 911 call, we know that. What sort of electronic recording, if at all, is what we're talking about specifically?
So in essence, it's a radio call from a car to the center. So police officer to the center asking for a crime report number. Because the way police agencies in Monroe County get crime report numbers is that they get them from OEC. So there was an original crime report number generated as part of this investigation. There was an additional crime report number that was generated as a result of the officer asking for a crime report number so they can execute the warrant.
So it's not an external call?
No,
It's an internal
yes.
radio transmission?
I believe so, yes.
Wasn't there a radio call asking that someone to come to the station to interview a sexual assault victim? Wasn't
No.
that also one of the?
But that would, no, because it was in essence, it was a walk-in. She walked
No,
into
but
the agency.
Weren't they calling the investigator, telling him to come back to the station?
No, that's not what was disclosed.
And not all we're really talking about, that makes it seem so less than important, but that's not what I mean. There's automatic discovery, and then there could be other discovery.
Yeah.
Right? So the defendant's not precluded from saying, hey, I think there's X, Y, and Z. Can you produce it? Go get it for me, please. But that doesn't mean necessarily that, even though you could go get it, it doesn't mean that it's part of automatic discovery.
Yes.
And which is recounted in the certificate of compliance.
Yes, and I'm not sure, because I believe there's still a function for discovery requests in motion. I believe attorneys are still making discovery requests in their motion for things that may or may not necessarily be automatic discovery. But we're also talking about a process, again, we're talking about these calls. The certificate of compliance was never challenged. The supplemental certificate of compliance was never challenged, and that was the obligation of defense attorney to challenge the supplemental certificate of compliance. He didn't. He waited 6 months, and then he filed the motion for a speedy trial. The question became, was that supplemental certificate of compliance valid? And it has to be, because they never challenged it.
Does he have an obligation to challenge it if the statute said it should be turned over automatically?
Yes. After May 9th, yes. It was his obligation to challenge the supplemental certificate of compliance. And he
Even though
didn't.
245 says you must turn it over
Correct.
automatically,
Correct.
he has an obligation. Isn't the burden on the people, not the defense, to turn over the discovery?
Yes, and
automatic discovery?
if that is not turned over correctly, if there's any issues with the certificate of compliance, it's the burden is now on the defense attorney to challenge it.
Now, I have a question about the certificate of compliance. Did the certificate list Hasback and Sergeant Hughes as witnesses on the certificate of compliance?
I don't recall. I actually don't recall standing here now. The position at the motion stage was that they were non-testifying witnesses. I believe you're getting to the Giglio issue.
Right, I'm getting to the
Yeah,
Giglio.
so I don't know if they were listed as witnesses on the certificate of compliance, but even if they were, there was no intention of calling either of those witnesses.
Then why would you list them? Because wasn't one of them responsible for uploading electronic information?
I believe our
Sergeant
obligation
Hughes?
under 24520 is to list them. I don't necessarily, my position isn't necessarily that we're not we have no obligation to not list anybody who might be a witness.
Well,
The issue is,
Sorry, real quick, Mr. McCarthy. Go ahead, finish your point, then I'll take your answer.
Okay.
You're getting a lot today.
I really am. The issue is whether they're testifying. So when you read the Giglio provision in 24020, it refers to 24520. It refers to two things. This court has interpreted the first requirement that the Giglio material be germane to their testimony. The second part of that statute is they have to be testifying witnesses. These witnesses were not testifying witnesses, and as a result, there was no obligation to turn over their Giglio material.
So subsection D, I think, is what we're talking about, where you have to disclose the name and work affiliation of all law enforcement personnel whom the prosecutor knows to have evidence or information relevant to any offense charged or to any potential defense thereto.
Yes.
That's step one.
And
Later on, it says, but the prosecution shall notify the defendant in writing that such information is not to be disclosed, etc. But there's a portion here that I skipped over, I'm sorry, where don't you have to say whether or not a witness is likely to testify?
In writing, or, I'm
At
not
some
sure,
point.
I'm not
At some
sure
point.
if that requirement's in writing. But they, in any event, the defense was notified these witnesses were not testifying.
Forgive me, I skipped over the after the paren, I read
Okay.
too quickly. Including a designation by the prosecutor as to which of those persons may be called as witnesses. So, first of all, you have to decide, do they have evidence or information relevant to any offense charged or defense thereto? And secondly, disclose if they're going to be witness, which you
Yes.
did, and you said they're not going to be
And
witness.
they're not going to be witnesses. And again, I go back to the fact that we're also talking about the standard under striking a certificate of compliance, that procedure wasn't complied with.
Do you want to hit weight of the evidence briefly?
Yes, so under Delamota, the court, in order to reject a jury's verdict is against the weight of the evidence, the complaining witness's testimony would have to have been hopelessly contradicted. And I don't believe her testimony was hopelessly contradicted. I don't believe they proved that it was impossible for him to carry her up the stairs. This was his house, so I'm sure he was well familiar with how to get up and down the stairs. I don't believe their testimony about...
Well, I mean, you could live in a house, you could live in a house and not carry bodies over your shoulders up and down the stairs ever, right? I mean,
Yes.
so I don't know, living in a house tells you that, oh, I know this, right?
But he would have traversed those stairs.
But your argument is, he knows the stairs, and if he needed to duck down or something, he might have been able to do that.
And they certainly didn't offer a demonstration to that effect. There was no video demonstration of it. In essence, what they did was they took measurements and said, see, it's impossible. But he lives there, he walks up those stairs every day. I don't believe that evidence has any sort of bearing on the verdict. And if there's no other questions?
Thank you, counsel.
Thank you.
Case 908, People versus Bookman.
May it please the court, with the people failed to disclose the jail surveillance video, which would have shown what occurred outside Mr. Bookman's jail cell, the recording which was required to be disclosed pursuant to CPL 24521G, the court's ruling refusing to preclude evidence as to what occurred prior to the officer's entry into the cell.
The charge the court gave was insufficient. That's your argument.
Absolutely. The court's ruling was based on two erroneous components. One, the court refused to impute to the prosecutor the knowledge that the sheriff had as to the existence and possession of that video. The court's refusal to do so is in violation of the statute 24520 subdivision 2 that expressly says that the prosecutor is deemed to possess all discoverable materials in
Counsel,
possession.
what was the timing on this? In other words, when should they have known that the video was going to be important? And I guess what I'm getting to is, would it have been before I think the rule was every 30 days they tape over?
Actually, it was 6 months, by the way.
Oh, excuse me, 6 months. So every six months they tape over these. Were they on notice within that 6-month period of time that this tape was going to be important and they should preserve it? Or is it required that they get a demand for it?
There's no, first, a couple of things. There's no demand requirement in the under 245. Under 240 was a demand requirement. The answer to your first question is yes. And they were required to know about that and have that in the initial certificate of compliance. And the reason for that, and the reason that they didn't, that people say, well, we didn't know about that. When the statute first passed, we sent a general checklist to the sheriff saying, here's all the stuff we want in each case, and they never did a case-specific follow-up. The statute requires, not only imputes the knowledge of the sheriff to the prosecutors what's possessed, and therefore, and it separately imposes a duty to under 245.55 to ensure the flow of information is maintained between the prosecutor and law enforcement to make sure that all material and information pertinent to the case are provided to the prosecutor. Prosecutor failed an obligation. Again, similar to my last case, this is a problem of lack of due diligence by the people and by the sheriff. The people failed to exercise due diligence because they just relied on that one-time sending of a checklist and of information and never followed up. If that is sufficient, then in that county, that one-time sending out a checklist means they can never have a violation of 245 when police withhold or fail to provide information because, right, they asked for it once in a general thing without any case-specific follow-up. That's the opposite of what the statute
Mr. Schifrin,
provides.
as I understand your argument on appeal, and if I've missed it, please let me know.
Sure.
You are contending that a different sanction should have been applied by the court.
That is correct, Your Honor.
You're not, this is not a 30-30 case,
Correct.
like some others that we've got.
Yep.
Okay, so you're saying that the court should have stricken that video evidence or do something more?
It's not striking video evidence. The video would have shown what occurred outside the
What's the
jail cell.
sanction you're looking for? That's my
For
question.
preclusion of the sanction we're looking for is preclusion of testimony as to what would have been shown by the video, which is what occurred prior to the entry into Mr. Bookman's cell. This is important, and what reason Mr. Bookman was so prejudiced is, in this case, we know that six correction officers entered his small cell, and then one officer sustained some injury, which is the basis of the assault thing. The 5 officers testified that the reason they entered that way was that prior to the entry, he was acting in a strenuous manner, that he was throwing wads of toilet paper, cups of water out, and they had to go in. It's important to note that no wads of toilet paper were ever found or placed in evidence. No cups were ever found. No photos of any wet spots were ever found. There was no corroboration of this. The recording, which was not turned over, would have shown whether or not these officers were telling the truth or not. They would have shown what occurred. Indeed, the district attorney in their brief says that the behavior prior to entry shows Mr. Bookman's intent when he did enter. But we don't know what their behavior was because we don't have the recording. They want to benefit from the destruction of this evidence, the failure to provide this evidence. Going back to the initial question by Justice Curran, the failure here was a failure, first of all, the refusal of the court to impute the sheriff's knowledge to the prosecutor despite the statute, and despite the trial prosecutor conceding it is imputed that we know everything that exists. And also, this failure number 1, failure number 2 is a failure for either the prosecutor or the sheriff to exercise due diligence. It was the sheriff getting the checklist should have
I want to make sure I
turned
got
over.
it right, Mr. Schifrin. The sanction that I understand you're really looking for is that the court should have precluded any testimony from anybody with respect to what happened before they entered the cell.
That's correct.
Okay, but instead, the court gave the defendant an adverse inference, right?
That's also correct.
And you would agree that is quintessential an act of discretion, one way or the other, with a multitude of factors, including prejudice, including the circumstances of the case, etc. But that's what we're looking at, is whether or not you were entitled to that sanction as a matter of discretion, and the court shouldn't have exercised its discretion to do just an adverse inference.
That's correct, with the 2 caveats. The problem is, in exercising the discretion, the court found incorrectly and erroneously that there was not a 245 violation because he found due diligence and he found that he's not going to impute knowledge. So the premise of the discretion was incorrect in both respects. So you have an abuse of discretion or a failure to correctly exercise discretion because the court based it on incorrect rulings, both with respect to the deemed knowledge by the prosecutor of what the sheriff possessed and the failure to exercise due diligence.
I didn't look at the record to see whether or not there was other video evidence disclosed. Was there any other video evidence disclosed?
The only other video evidence, despite all the other officers who were there, one officer turned on the body-worn camera after ordering the cell. It doesn't even show the incident.
Now, time out. It would be totally unsurprising to anybody that's been in the law handling criminal cases or even civil cases involving inmates to understand that there's probably video in the hallway somewhere, someplace, right?
Yep.
And is it sort of shocking to you that nobody asked, geez, where is that video? And when the people filed their first certificate of compliance, that was within a month or 2 at most of the incident. So the video was still there, presumably, because it doesn't get destroyed for 6 months. But nobody asked for it.
Again, under 245 at the time that occurred. There was no obligation on the defense counsel. The only party that had obligation was the people, and the people, using your example, should not have been shocked that there are cameras on cell blocks, and they never asked for it. They never asked when they got the materials and it wasn't there. They never said to the sheriff, "Is this everything? Were there any videos?" They didn't do that. The sheriff failed in his obligation to turn over those videos, and the evidence that's missing is, again, extremely prejudicial because we have this one-sided picture of what occurred, not corroborated by the physical evidence that should have been there if you accept the testimony of these officers. Under these circumstances, the adverse inference charge was woefully insufficient. The people rely on cases cited, first of all, before 245 and don't involve what the appropriate remedy is when the failure is as a consequence of 245, and again, in this case, where the prejudice we urge is great. I'd just like to briefly...
Could you, by any chance, turn to the harsh and excessive argument in light of the defendant's mental illness?
Yes, Your Honor, and I'd like to go back to point 2, if I may. We're urging that the imposition of the maximum sentence on these facts, and the facts here is that when 6 officers entered the cell, 1 officer testified that when he was in a, and this relates to point 2, he and Mr. Bookman grabbed each other. Mr. Bookman twisted, that officer fell down and hit his shoulder on the toilet, injuring it. That to impose the maximum sentence under those facts, given Mr. Bookman's lengthy history of mental illness, the fact that the injury sustained was relatively minor, and there was a significant discrepancy between the sentence imposed and that which was offered pre-trial, we believe was inappropriate, and the sentence should be reduced. With respect to point 2, just following up on that, again, despite 6 officers in the cell, and not only is there no body camera as to the incident, only 1 of the 6 officers, Officer Cornell, testified as to what occurred. And his exact words were, well, he testified, "I grabbed inmate Bookman by his jumper, pushed him to the back wall of the cell. He then grabbed my uniform. I had him with both hands. He had me with both hands. He then pulled and twisted me to the left. When he did that, that's when I fell and struck the toilet." That shows an intent to avoid restraint. It does not show an intent to cause physical injury. Indeed, the officers who entered caused injuries to Mr. Bookman to show up on the body-worn camera. They didn't have the act with the intent to cause injury. They were acting to restrain him. The facts here are very similar to those in People v. Traber, which I cite both in my main brief and my reply brief, where again the court held there was an intent to get free. There's not an intent to cause physical injury. That single act of when you're grabbing someone, someone's grabbing you, and you twist them, and the person falls and hits the metal toilet in this very small cell where there's now 7 people, doesn't evidence an intent to injure. The cases cited and relied on by the people on that point all involve defendants' actions that are that are qualitatively different than Mr. Bookman. In one case, the defendant punched the victim several times, including while the victim was unconscious. Another case, the defendant, after fighting with the decedent, shot the decedent. In a third case, he approached with a knife and slashed the victim's throat. That's not what we have here. To find intent to cause physical injury here, I think, is inappropriate. And finally, as I noted in a brief, they could have charged him with assault to the same level of offense under a different subdivision that didn't require intent to cause physical injury. Having made that charging decision, the people put the onus on themselves. Thank you, Your Honor.
Thank you, Counsel.
Good morning. May it please the court. I'd like to clarify one issue here that came up very early in the argument, and that has to do with whether or not the people were imputed to have knowledge of the video at issue in this case. The law does not impute knowledge to the people.
Does common sense impute knowledge?
The law imputes possession in this case, Your Honor. And I would also point the court...
This is a jail, right? Somebody's
yes,
in a lockup.
Your Honor.
Anybody that's been in these facilities, which a lot of us have, know there's cameras everywhere. There needs to be.
There are cameras throughout facilities, typically, Your Honor, yes, although...
Is that not something that would typically be looked at as part of an investigation to determine what happened?
Yes, generally speaking, you're going to look for all of the video that's out there. But what I'd like to point the court's direction to with respect to this exact issue is a section that defense counsel himself cited, which is CPL 24555. But I'd like to look past subsection 1. Subsection 1 does provide for a free flow of information between the people and the law enforcement. But if we go further down, subsections 2 and 3 actually discuss what the role and responsibilities of law enforcement are with respect to the people. And I'd like to focus on subsection 3 in particular. It discusses recordings, audio, visual, 911, but it encompasses surveillance video, body-worn camera, etc. And it actually places an obligation on the lead investigating officer with the law enforcement agency in order to identify all of the video related to the case and provide a written notification to the prosecutor's office as to the existence of those videos. And subsection 3B specifically states that where a video is not disclosed by the people because of a failure of law enforcement to fulfill their duty on notifying the people as to the existence of videos, what the court's response then is a 24580 sanction. And it puts us directly and squarely into 245. There's no question in this case, and nobody argued at the trial court that there was bad faith here. It was good faith, and it was agreed all the way around. And there's also no question that the people knew about the existence of this video beforehand, and nobody indicated that law enforcement told them it existed. In fact, the whole point of this is nobody from law enforcement said anything about this video to the people until we were talking to them as witnesses. And so once that was discovered, the people went to look for it. Once they realized that that video was out there and that it had been missed, they went to look for it, and they made it known in this case that it wasn't there.
Let me get back to my first question. You're saying that the people were not told of the existence of the video.
It's correct, Your Honor,
Right?
yes.
In this circumstance, doesn't common sense tell you there's going to be the existence of video and that there ought to be an effort undertaken to go look for it?
There's still a question as to what videos may be out there, and I would argue, Your Honor, the role of the lead investigator from law enforcement is to identify those videos. There's a certain degree to which the people are expecting that the law enforcement agency is doing precisely that, and the law
In
is...
the normal circumstances, I might agree with you that the DA can say, look, at law enforcement have an obligation to make sure any video are sent to us. But doesn't your office have an obligation here too? In circumstances where you know there's a high likelihood that there's video there?
Well, I don't know, Your Honor, that we can go to the point of saying that we know there's a high likelihood of video. Is it reasonable to believe there could be surveillance footage? Yes. But we don't necessarily know where in the jail, what wings, or that they're even there.
Or that there's not an assumption that there's video all over the jail?
Not necessarily. I think there's an assumption that there's some surveillance system. I don't think that there's necessarily an assumption as to the extent of it. And I think to do this...
I don't want to beat a dead horse. Go ahead. Go ahead with your argument.
Understood, Your Honor. But I just want to also address, Your Honor, the nature of the sanctions question, because I think the heart of this is the sanctions question. What's the appropriate sanction here? And I want to point directly to CPL 245-80, subsection 1B, because that's where we are. We're in a situation where there's missing video that wasn't disclosed, missing material or information generally that wasn't disclosed. And in that situation, what's provided for is that the appropriate remedy or sanction is that which is proportionate to the potential ways in which the lost or destroyed material reasonably could have been helpful to the party entitled to disclosure. So fundamentally what this is about is ensuring a fair trial and mitigating the prejudice that would be caused to the defendant based upon the value of that evidence. We're not asking questions necessarily about the nature of the prosecutorial action in this question here. We're asking about what's the damage to the defendant and how do we fix it. And we're talking about a surveillance video that showed the events that occurred outside of the cell. We have body-worn camera that gives a depiction of what happened inside the cell. That was disclosed. That was known to the people. We found that, and that was told to us by law enforcement that it existed. What we're dealing with is a question of what happened outside. We've got 5 eyewitnesses who testified to what occurred outside. So what can that video offer? Because that testimony is there. That video can offer some sort of impeachment or rebutting of what those officers testified happened, something that would undermine the credibility of their testimony. So then you have to ask yourself, what remedies do we have available to us? And in this case, the court chose an adverse inference. And I would say to this court that that was the right choice, because an adverse inference in the instruction as given told the jury they were allowed in this circumstance to assume that the video that's missing was favorable to the defense. In other words, the jury can assume that all of these witnesses are not telling the truth about what happened outside of the cell if they deem that that's appropriate in this circumstance. It gives the defense exactly what that video could have given them in the best circumstance. It fits like a glove to this case, and that's exactly why under the prior law, this is the instruction that was given in this situation. When you look at People versus Handy in particular, what we're looking at is a case where it was a jail assault. And in that case, the people knew about the video, the sheriff had viewed it, and the video still got left to go away. And the Court of Appeals there found that an adverse inference instruction was the appropriate instruction. We look at People versus Durant, another Court of Appeals case, where it dealt with a situation where there was a custodial interrogation and no video was taken. Now, there's no obligation there, and the court decided that there was no sanction appropriate because there was no obligation. But they went on to directly discuss what is an adverse inference instruction used for. And an adverse inference instruction is used as a penalty for the state for violating statutory or constitutional duties, or, and this is the important part, the destruction of material evidence. That's the purpose of an adverse inference instruction. And the reason it's the purpose is exactly what I described, which is that it fits like a glove to the harm that lost evidence presents, to the prejudice that's presented, and in that way offers the best remedy. And defense continues to ask for a preclusion of evidence, believing that that would have been the appropriate remedy here. Let's just not even go there, is essentially what I understand their argument to be. It's better, since the video's gone, we just don't go there. But the courts in this state have consistently held that preclusion is a severe remedy, and it should only be applied where there is no other lesser remedy that can remedy the prejudice.
I suppose if there had been preclusion, there would not have been an adverse inference, because the testimony would not have been received about which the adverse inference applied. So it's sort of a either or, and the court chose one over the other. As I understand your point is, that's quintessentially a question of discretion for the trial court.
This is true. It is a question of discretion, and this court would have to find that that was an abuse of discretion. There'd have to be some compelling reason to suggest that preclusion of evidence was more appropriate, that there was some level of harm that an adverse inference simply couldn't attend to. But I would again point to the fact that the adverse inference tells the jury they can assume the video showed exactly what the defense, in its best case, would hope it showed. And for that,
further, counsel?
the only further point I would indicate is that on the intent issue, defense counsel indicates that there was an intent to avoid restraint, and that for that reason there was no intent to cause physical injury. But I just point this court to Chittick. The Court of Appeals held that intent to avoid restraint by causing substantial pain was intent to cause substantial pain and therefore cause physical injury. Those two are not mutually exclusive.
Just one factual question.
Yes, Your Honor.
When Officer Dando first approached the defendant before all of this occurred, and he was already acting out, I think had his pants down and was being loud and disruptive before the throwing of the toilet paper and all of that, she asked him twice if he wanted his medication, and he didn't answer her. He was in whatever state he was in, so that he didn't answer her, and she said she took it as a refusal. Did the record reflect what medication it was?
I don't know that the record reflected exactly which medication, Your Honor.
So you don't know if that medication would have been something that would have calmed him down?
No, I don't know. I would note on that point, if I might, just that there was no evidence raised that I recalled in the record at trial regarding mental health being a factor in his actions. I know there was some discussion in some of the non-evidentiary hearings about that, but I don't recall that there was any evidence that suggested that the reason that Mr. Bookman acted the way he did was as a result of mental illness in the actual record or trial.
Counselor, take us to the sentence. Why is it that you think it would be appropriate to not find why shouldn't we say this was harsh and excessive, given the mental health issue and given the fact that it was the maximum sentence? Why was that appropriate?
Because we're dealing with a situation that's qualitatively different than the cases that were cited by the defense. You were looking at factors in those cases where there was limited to no criminal history, no prior or other assaultive behavior in the case. There was a long history of mental illness, and there was evidence at trial that bore directly on the mental illness affecting the defendant's ability to form intent. There was expression of remorse, and all of these factors taken together were the basis for why this court would lower a sentence. Those are not present here. We have a defendant here with an assaultive history. We have a defendant who was continuing to get into assaultive issues in jail while the trial was pending, while sentence was upcoming after conviction. We have a defendant here who presented no evidence regarding the impact or presence of his mental health issue with regard to his conduct in this case.
It was in the pre-sentence investigation, wasn't it, regarding his mental health?
I
His whole
believe-
history of mental health.
I believe there was an indication of prior mental health issues, but there was no evidence that was presented that suggested that his mental health was a factor in his ability to form intent in this case. Also, Mr. Bookman continued through the pre-sentence investigation report and also at sentencing reiterated when given an opportunity to speak that the reason he acted the way he did, and these are his words, is because other people were picking on him in the jail. He says that at sentencing and actually tries to put the blame on other people than himself, that other people were goading him into it. He doesn't say that I recall that I was losing my mind or that I was having some issue along those lines. He blames other people for picking on him because they saw him as an easy target.
Counsel, you should begin to wrap up.
Okay, understood, Your Honor. I just would, again, encourage this court to uphold the sentence for the reasons stated and to find that an adverse inference was not an abuse of discretion in this case, given that it fits perfectly with the harm that the lost evidence may have caused to the defendant.
Thank you, Counsel.
Thank you, Your Honor.
Case 909, People versus Shaw.
Presiding Justice Whalen, and may it please the court, I'd like to focus my argument today on point one, the Lopez argument. Mr. Shaw unequivocally and repeatedly negated the intent to cause serious physical injury required for manslaughter.
Let's get right into it then,
Sure.
Counsel. In reading the transcript, it appears that, I see exactly what you're saying. There's a number of times where he goes through and he negates elements. But I think the court at one point turns to the prosecutor and says, is that it? Or words to that effect. And the prosecutor begins to ask further questions, realizing that there's some problems. And after that, doesn't the defendant admit 2 times that he fired the gun with an intent to cause serious physical injury? And don't we have many cases where there are problems during the plea colloquy, but they're corrected? And isn't that what happened here? And if not, why not?
No. There are a series of cases, Thiel and Trinidad, cases that the people rely on, where this court said that the defendant's subsequent statements removed any doubt as to the intent to cause serious physical injury. But Mr. Shaw's one-word answers in response to the prosecutor's leading questions, I would submit, do not remove the doubt that was cast on viewing the allocution in its entirety. We don't look at his one-word answers in isolation. Among the things that we have to look at is not just the prosecutor's inquiry, but also the court's inquiry. In light of the court's inquiry and then ultimately the prosecutor's inquiry, viewing that all that in its entirety, I think a reasonable view of the allocution is that Mr. Shaw may very well have been conflating the mens rea of recklessness with intent when he gave those one-word answers, and may very well have been allowing the prosecutor to put words in his mouth in order to get his guilty plea accepted. Thus, doubt remained, as to the question of intent, and the court was required to conduct a Lopez inquiry. As to the court's inquiry, the court equated question of intent with the question of recklessness. The court asked Mr. Shaw, well, you knew that you had a gun. You knew that it was loaded and could fire bullets. You knew that at least it was likely that if one of the bullets struck the victim, it could cause serious physical injury. And you knew that by firing towards the vehicle, you could be causing serious physical injury. Mr. Shaw's answer evinced a mens rea of recklessness. I knew I could have, but I was only trying to scare the victim. Neither the court nor the prosecutor said anything to correct the court's confusing statements as to mens rea. The prosecutor, as you noted, Justice Whalen, repeatedly asked Mr. Shaw whether Mr. Shaw intended to cause serious physical injury, but nobody defined what intent to cause serious physical injury is, creating or causing or having the conscious objective to cause serious physical injury, and nobody explained the difference between the two differing mens rea. And then there's a very real question of whether Mr. Shaw was simply answering yes to the prosecutor's leading questions to accept the benefit of the plea bargain, to get his guilty plea accepted. As Judge Wilson said in his dissenting opinion in People versus Tiger, people sometimes admit to conduct they didn't do in their plea allocutions in order to get a favorable plea deal. And by taking over the questioning as the prosecutor did, the prosecutor signaled to both Mr. Shaw and his counsel that Mr. Shaw's were unacceptable to get his guilty plea accepted. And counsel got the message. Counsel took Mr. Shaw aside, spoke to him off the record, presumably to tell him, listen, you've got to give it a different answer or your guilty plea won't be accepted. To be clear, I'm not contending that once Mr. Shaw said, or negated an element of intent, he couldn't thereafter plead guilty, and his guilty plea could never have been accepted. But the court was required to make sure that before Mr. Shaw answered those leading questions, two things. Number one, he understood the difference between recklessness and intent, which the court gave confusing instruction on. And number two, that Mr. Shaw's answers, yes, those one-word answers were not just given to get the guilty plea accepted. As to the latter point, I would suggest that a court in those circumstances could ask open-ended questions like, what were you trying to do? Mr. Shaw said, well, I was trying to cause serious physical injury. That would give us the assurance that we need in the circumstances. Or the court could have elicited a description from Mr. Shaw as to the incident itself, in his own words. That wasn't done. Short of that, the court should have conducted a Lopez inquiry, advising Mr. Shaw that he had negated an element of intent, and then ask him if he still wished to plead guilty. But the court did none of this. His guilty plea should be vacated.
Thank you, counsel.
Thank you.
Good morning again, Marty McCarthy for the People. Defendant's answers were inadequate at the time the prosecutor began the colloquy. If the colloquy had ended there, that we would be arguing a Lopez issue. This isn't a Lopez issue. The prosecutor was permitted to ask questions. Nobody objected. The questions were asked. The defendant admitted to the material elements of the reduced offense, by the way. This was a reduction off the murder 2 count. And then he never made a motion, in essence, arguing what he's arguing in appeal. He never made a motion to vacate his plea afterwards. So in that sense, this isn't a Lopez case. The elements were not negated. He was required to preserve this contention he's now making on appeal with a motion. He didn't do so. There are no other questions?
No questions, counsel. Thank you.
Thank you.
Case 910, People versus Mohammed.
May it please the court, Peter DiGiorgio for the appellant. I'm going to primarily focus on points 1 and 2 and just briefly comment on point 3 today.
Counsel, in point 1, pre-trials, just confirm if I've got this right or wrong. Pre-trial, the defendant was offered 3 years plus 5 years post-release supervision.
Correct.
Okay.
That was 3 days prior to trial.
3 days prior to trial.
Correct.
And after trial, it was increased to 10 years with 5 years post-release supervision.
Correct.
Part of your argument is, I think, what changed in terms of the judge's knowledge of this case 3 days before trial versus after trial that could justify such a multiple of 3+ on the sentence?
Absolutely, Your Honor. And I'm going to tell you why this is a perfect storm for a case for arguing that the sentence was harsh and it was enhanced. Not only did the people know 3 days prior to trial, presumably they met with their witnesses, but the people's theory was that the defendant had brandished a gun and held the gun to the victim's head and then took the car. And this is somewhat going to point 2 of my argument, but the jury must have acquitted him or must have discounted that there was ever a gun brandished because they acquitted him on counts 1 and 3 of the indictment. So not only do we have the factor that the people knew everything about the case, but after the trial, the people were bound to acknowledge that the jury did not find that he brandished a gun. So that put him more equal to the same footing of the co-defendant. There was a co-defendant in this case that was also in the car, that was acting as presumably an accomplice. They got a plea deal. I believe he got 3 years, and there's some discrepancy in my brief. I noted 3 years, but I believe it may be 3.5 years that the co-defendant got. So this is the second prong of this perfect storm, and that the co-defendant was offered and pled guilty to 3.5 years. Now, I acknowledge, I've argued this point or a similar point before, that to give a defendant at time of sentencing the exact sentence he was offered 3 days prior to trial, we wouldn't have plea bargains. We would have everyone going to trial. So I understand there's some risk that the victim had to testify. But prong 3 of why this is a perfect storm. The victim was not harmed. The victim got his vehicle back. There was nothing stolen from the vehicle. And although I don't want to downplay what happened here, it's a serious crime, but it's not that far away from the crime of unauthorized use of a motor vehicle. These individuals knew one another. The victim had been given rides to the defendant previously. And yes, I'll acknowledge that the defendant did say, give us a ride or I'm going to kill you. He did make that statement. But this is not a stranger coming up to an individual saying, like in the old gangster movies with his hand in his pocket, give me your money or I'm going to kill you. So I would argue at least 3 prongs of 4 prongs I'm going to mention to you for a perfect storm. The other is that the defendant is a first-time felony offender. He's got no prior felonies, and he got 10 years when the co-defendant got 3 years. And I would argue that the people knew much more about the case that militated in favor of the defendant. Now, the people in their brief mentioned that he gave some inconsistent statements to the police and at the grand jury. Well, if we're going to hang our hat on that, every case where a defendant gives a statement and he's convicted of something that contradicts his statement, you can argue he should be given an enhanced sentence, and we shouldn't bootstrap it for that. So I believe this case calls out for this court to invoke its jurisdiction to modify this sentence to something reasonable. I put point 1 as an enhanced sentence for going to trial, as well as harshness of sentence. And understand it may not be the type of case where the judge specifically says, you wasted my time and took me to trial and I'm going to make you pay for that. But realistically, what happened 3 days prior for trial where the people were ready, or the judge was ready to accept a plea to a felony for 3 years, in the conclusion of a trial and sentencing where he got 10 years?
Very often in these cases, what happens is being told as a judge what the facts are of the case and what's expected to be proven at trial is one thing. What happens at trial when the testimony comes in and the victim comes in is sometimes more elaborate and more detailed than what the judge was told. And so it's not unusual at all, especially when the victim, as you pointed out earlier, being called in to testify and has to testify because there was no plea taken, for an enhanced sentence. You're simply saying that, yeah, an enhanced sentence, understood, but this is too far. This is too much of an increase, based upon what the judge knew. There might have been more information provided at trial, but how much more could there have been?
Yeah, and Judge Whalen, to follow up on that, not only was more information that the judge gleaned from the trial, but it wasn't information that hurt the defendant. It was actually information that helped the defendant. The jury disregarded and did not find that he brandished the gun. So he made the threat. I'm sure the only way I read the plea, the verdict, is that the jury must have concluded he threatened to kill him. The victim believed it, and he handed over or allowed the defendants to take the vehicle.
Did you want to get to the weight and insufficiency argument?
I do. At point 2, I'm seriously questioning whether there's sufficient evidence of forcible stealing here. I know he made the threat, but the jury disregarded there was brandishing of a gun. So I got to think, I would argue to this court that there's got to be some indicia of proof that he had the ability to carry out a threat, that this just wasn't talk. And I cited some cases in the brief where, not every taking of property is a forcible stealing.
Well, certainly the evidence here, and you correct me if I'm wrong, again, you know the record better than I, but my understanding of the testimony of the victim is, and from other witnesses, that the victim fled that vehicle in a hurry and was running away from it. In other words, it wasn't, some kind of calm, get out of the car, close the door, see you later, and off they drive. That certainly is some proof that there was a force exit of that vehicle, and the defendant took over the car, and then did clearly drive away with it.
I guess if there was, Your Honor, if there was more testimony that the defendant said he had a bulge in had his hand on his coat, and there was a bulge there, and I feared he had a gun. But the victim said he put the gun up to my head and held it, and I believe inferred that he saw the barrel of the gun, and that's why he surrendered the vehicle. The jury rejected that argument. So the fact that that threat was made contemporaneously with that act, I think this court could look at the substantial rest of the evidence and conclude that the whole proof of that threat should have been rejected. The van was found very close to where it had been taken. I understand.
And there was a wallet in the van, and it was the victim's wallet that wasn't taken. We understand that part of the record. Counsel, anything further?
So, yeah, I would like the court to look at whether, considering that the jury rejected the brandishing of the gun, whether it's sufficient proof of force. I do think it's preserved in the motion. The counsel did preserve the issue by stating it was with respect to the menacing charge that there was not proof of force. With respect to my third point, just very briefly on the verdict sheet, I understand it's not preserved, and I know the high hurdles, because I've argued this before in front of this court, to get over the verdict sheet problem. But contrary to what the people cited in their brief, the verdict sheet wasn't misleading. It was wrong. The second count, which is the top count he was convicted, eliminated an element that, in other words, that another person be physically present, and it duplicated count 4. So I think under these circumstances, this court has to take some action. And I understand the hurdles with the preservation, and there was no objection, and there was arguably a consent to that. But I think when the verdict sheet, the annotation is in effect wrong, that something needs to be examined, especially when it's the conviction for that top count of the indictment.
Thank you, counsel.
Thank you.
May it please the court, Dawn Katara-Lupi for the people. In regards to the first point, I just want to clarify that the offer that was made prior to trial, or three days prior to trial, was to an attempted robbery in the second degree and a sentence of 3 years, which the defendant could not have gotten with what he ended up being convicted of, because the minimum is 3.5. Also, the original offer was 6 years in prison, which he had rejected.
But you don't disagree. The original was 6, but it was then reduced just prior to trial.
Correct.
To 3 years.
Yes, I don't disagree with that.
And this is a substantial increase, relatively speaking, to 10 after the trial.
Yes, Your Honor. I don't disagree with that.
So what is it that the court might have learned that would have resulted in that increased sentence so that we're comfortable that it wasn't a penalty for going through the trial?
I understand that. Well, I think there were several, I submit to you there were several factors that the court considered in imposing its sentence. First of all, the proof at the trial showed that this defendant was the main perpetrator of the crime. If you look at the record, the victim's testimony is that the defendant was the person who he believed had a gun. He was the person that yelled and screamed and threatened him, whereas Mr. Ganiso, who was the co-defendant, who had pled guilty, basically was trying to calm him down and talk him down and say, come on, let's just talk about this.
But that was known to the judge before the 3 days before trial, right?
I don't know, Your Honor. I don't know what, I assume that the court read the grand jury minutes. The court had to read the grand jury
Right.
minutes. Also, the co-defendant was cooperative with law enforcement. The co-defendant took law enforcement to where the vehicle was, which was not where it could easily be found. It was several blocks away from where the defendant and the co-defendant were staying, and not anywhere near the victim's house, which was about 1.5 miles from where it was taken. And also, the co-defendant led the police to the keys, which were hidden in a vent in the house where he and the co-defendant were staying. So he was cooperative. The defendant was on probation at the time. It was for misdemeanor probation, but he was on probation. And he had a pending felony charge of criminal mischief felony at the time of the trial. So these were all factors that the court could have used to enhance the sentence.
Was the defendant
also-
arrested
I'm
for
sorry.
something before he was sentenced? Was the defendant arrested for something else?
It appears that he was arrested for criminal mischief, and it's hard, it was hard for me to tell, and I kind of had to, I can't go outside the record, so I'm looking at the pre-sentence investigation. It was a pending charge. Whether it occurred after he was arrested or before or around the same time, and apparently the charge must have been dismissed after he was sentenced on this case because there's no record of a conviction. Actually, he may have pled to a misdemeanor, I'm not 100% sure. But he did have that pending charge. And if you look at the record for the original offer was 6 years, and it's going to satisfy a pending robbery investigation. Now again, what was involved in that never came to light, but there were several factors, our submission is, for the court to consider when enhancing the sentence at the time of the sentence. In regards to the second point, it's clear that the evidence was sufficient to support the conviction of robbery in the second degree, 2 counts. One was having another person present with him, and that it was an automobile. The force that was used, although the jury decided to not find beyond a reasonable doubt that there was a weapon, that's not the same thing as saying that there wasn't a weapon. They just did not find beyond a reasonable doubt that there was a weapon. Nobody else saw a weapon beside the victim. It was clear that he felt threatened. He, as you said, Your Honor, he ran from the vehicle. He said, take the keys. He wanted to take the keys, and they said no. He left. He immediately called law enforcement. And I think also this court needs to look at the credibility of the victim here. It's clear that that's what the jury did. They looked at the victim's credibility as opposed to the defendant's credibility. And it's important when you look at his inconsistent testimony between what he told the police, which was, I got drunk and got in the back of a car, and what he told grand jury was, he gave us the keys because he was too drunk to drive. So he told wildly inconsistent stories about what happened that night, and the jury heard that, and they weighed the credibility of the victim as opposed to the defendant and found that he was threatened and that it was taken by force, and they meant to keep it from him. They hid the keys in the vent of a house where he didn't live. In regards to the third point, if I may just for a moment, that was not preserved in any way. It was, and if you look at the record, the jury came back at least twice and asked for those crimes to be defined. So it was clear that they understood, and the court made it clear to them that the jury instruction was not a substitute, or the verdict sheet was not a substitute for the jury instruction.
Thank you, counsel.
Thank you.
Case 911 in the matter of Annalise S. Counsel, we're going to hold up just 1 second to make sure that we have Counsel Gray on video.
Sure.
Counsel, can you hear us?
Yes, Judge, I can.
And we can hear you loud. Very good. Thank you. Please proceed, Counsel.
Thank you. James Hobbs, on behalf of the appellant, Ezra Bell. The main point in this appeal is pretty straightforward. My contention is that the summary judgment pleadings were insufficient and failing to show that the conduct, the abuse of Hannah Lee Sess was so closely connected to the care of Mr. Bell's 2 biological children that a derivative finding of abuse was warranted on summary judgment. There was a 7-year gap between the conduct involved in the guilty plea with respect to Hannah Lee Sess and the proceedings here asking for a finding of derivative abuse. And in the summary judgment motion or petition, there's no allegation of ongoing conduct, there's no allegation of a lack of rehabilitation, there's no allegation of an ongoing risk that relies solely on the...
Let me ask you where I'm kind of getting to in this and where I'm focused on. 2014, the father pleads guilty, I think, to sexual abuse, right?
Yes, that's correct.
And during part of the proceeding, there's father's sex offender treatment notes from 2018. So that moves it forward by about 4 years, right?
I'm not clear. Are you referring to the notes that were submitted with the petition?
Yes.
That were part of the supplementary record here?
Yep.
Correct. Those were attached to the petition, which was attached to the summary judgment motion.
And then, so 3 years later, 2021, the department sought the summary judgment.
Right.
In part relying upon, ultimately, the treatment notes. Can we rely on those treatment notes?
I would dispute that those are properly before the court at summary judgment. Okay. One, they're not referenced anywhere in the summary judgment motion. They're attached to they're an attachment to the summary judgment motion, and they're nowhere referenced in there. The pleadings in the summary judgment.
Let me get clear on what you're saying, just so I understand. Because I heard you say they're not part of the summary judgment motion, but they were attached to the summary judgment motion. So, in other words, are you saying that counsel, they weren't those notes were not relied upon in the argument of the summary judgment motion, but they were contained as part of the papers that were presented to the court?
The petition, the overall petition was attached to and referenced in the summary judgment motion. And then the notes were an attachment to that petition.
Right.
Right. Not the summary judgment petition, but the overall, like the complaint that starts a civil case, right? And nowhere, the summary judgment pleadings in the motion, they actually just reference the guilty plea in 2014 as sufficient on its own. They don't reference any other ongoing conduct. And so, nor did the court rely on them. So I don't believe that they were properly referenced or relied upon here.
But the issue that the court was struggling with, well, not necessarily struggling, but the issue the court had to decide was whether the defendant, or the respondent's rather, judgment and impulse control were so defective that he's likely to harm other children. That was really the standard, right?
Correct, yes.
Okay, and so your position is that in order to determine that, you don't believe that the court considered the June 2018 treatment notes?
I didn't see a reference to it anywhere in the court's decision, nor in the pleadings or in the argument from the petitioner, from the county.
But you would agree to that you know, how's he doing 4 years later may reflect upon judgment and impulse control overall, and whether it's defective.
I do agree that it could rely on it. There's still another 3-year gap as well, you know, that we don't account for. The standard is, yes, is it so defective? And I think that all of the case law, which I've cited in my brief, shows that this the gap in time is particularly relevant in determining whether or not it's so defective. The court has acknowledged that people can change over time. People can be rehabilitated. People can be treated for conditions. And so I think that some proof and some allegation, an argument to that effect, was necessary here. I also have a problem, just one other point, for relying on those treatment notes at summary judgment. You know, they're not referenced in the summary judgment motion, so I don't believe that there's an allegation that they are certified. I don't believe there's proof at that point that they would be admissible if there was a trial or hearing here. And there's also clearly the opinion in the summary treatment notes is based on the counselor's conversations with parole officers and based on, a lot of hearsay. So I think there are a number of problems with relying on that at the summary judgment stage, even if that the court had referenced
I
it.
just have one question. Is there a question of fact as to whether or not the denial of supervised telephone visitation with the older two children was appropriate?
I've raised that in the brief. I think that that denial was inappropriate. That's point 2 in my brief. I don't see that there's any risk, absent, there's not been a termination of parental rights as I can tell, and so there's no showing that he's having contact, having some relationship with his children remotely and supervised is going to pose any harm to the children. So,
Any further, counsel?
no, thank you.
Good morning, may it please the court, Elizabeth Moeller for the Department of Human Services. I would first note that appellant didn't make any argument in his brief or reply brief regarding the child Annalise, and as such, that finding of abuse, severe abuse, does stand. I would also note, I think it's unfortunate that the children Moses and Sophia did not have any representation in this appeal. Unfortunately, that attorney did not submit a brief. I would note, however, that his position in family court, as indicated at pages 63 and 64 of the record, he did support on behalf of his clients this finding that family court ultimately made. I would note that although appellant's counsel indicates that there are circumstances where someone can be rehabilitated, where they can be changed, appellant did not offer any such information in opposition to the summary judgment motion. He didn't offer any sort of information that he had completed classes or completed treatment. There was none of that in this case. I would agree with appellant that it's the so closely connected language from matter of Marino S. that we're analyzing in this matter. In this case, I believe, as Justice Nowak indicated, that closely connected language is whether the person's judgment and impulse control is so out of whack with what it should be in order to be a parent. Is that so closely connected with our concerns about this person parenting another child? And I believe in this case that it clearly is.
Even as to the older two children?
Yes, I believe that harm still exists. I think that, and I think that it is so closely connected. It is an act of this kind is so heinous that it can show that impulse control, that judgment is out of whack. But I also think that the treatment summary as well as should be considered, that was part of the petition which was a verified document, that information should be considered. So I think that there was other information before the judge. He didn't, the family court judge did not have to explicitly list it would have been helpful, it would have been nice if he had explicitly listed everything he looked at, but there's no argument about whether it was in front of him. He did have that information available to him when he made this decision. I would just note a couple in response to appellant's reply brief, he indicated that it was not appropriate to rely on his continued hospitalization because it was not before family court. I would note on page 61 of the record, in his own opposition to summary judgment, he does indicate that he was in a psychiatric hospital, which, that may be, you would have to draw the conclusions, but I think an inference can be made at that point that he was still being treated for the mental health situation. And then I would just briefly discuss the disposition of the denial of the visitation with the two older children. The standard at that disposition is solely the best interest of the children. And I don't think there was any evidence that they had a significant relationship with him, that they had had contact with him. I believe the last time they had contact with Mr. Bell, it was when there was a violation of his probation because he was having contact when he was not supposed to.
Right, but he was having contact, and one of the children was 8, so that would be a significant period of time that he would have had contact with that
But he was not supposed to. He was not supposed to be having that contact at all, and there was no indication that there was a significant relationship. I believe even in his testimony, Appellate indicated that the children were aware that he was their father, but beyond that, he hadn't had much contact. So if you're looking at it in terms of what their best interests are, I don't think the risks here would outweigh what the, any benefit.
Thank you, Counsel.
Thank you.
Counsel Gray?
Thank you, Your Honor. May it please the court, I represent Hannah-Lise, and I believe there might be some misunderstanding about the ages of the children. Hannah-Lise is the oldest child. The other two children are the younger two children that are as a result of the mother's relationship and marriage to the
Were they even born at the time that this offense originally took place?
No, they were not.
Okay, thank you.
And I think another argument that should be considered by the court is that Mr. Bell also violated the terms of his probation with respect to his severe abuse of Hannah-Lise. He saw the children, both Hannah-Lise and the other two, the younger children, and he was violated on that accord as well. The two younger children, although they're not represented here today specifically, I know that they're continue to be in a foster care pre-adoptive placement, and they've had no contact or relationship with Mr. Bell. And I would
How old are they now, Counsel?
Let's see. Moses is 9 and Sophie is 7.
Thank you.
And my client is now 13. So I would argue on their behalf that it would clearly be not in their best interest to suddenly have contact with their biological father, who severely abused their older sister. And I know that the Department of Social Services has initiated and will continue to allow the children to have contact with each other, even though the mother has surrendered her parental rights to the younger two. So on behalf of my client, I would certainly argue that the lower court order continue.
Thank you, Counsel.
Thank you.
Case 912 in the matter of Ahern B. Counsel, we have you on video. Can you hear us?
Yes, I can. Thank you.
Very good. We can hear you clearly. Please proceed, Counsel.
Good morning. May it please the court. Stephanie DeGiorgio on behalf of the appellant. There's only one issue in this case, and that is whether there was sufficient evidence that the respondent failed to exercise a minimum degree of care in providing food and medical attention to the child. I submit that there wasn't. There was significant testimony by the doctor in this case. The child, when he was born, weighed 5 pounds, 12 ounces, which the doctor said was on the lower side of normal, but was normal. And throughout his testimony, he noted that the child was consistently gaining weight at its regular medical appointments, despite being in the 5th percentile, which the child remained in the 5th percentile until April of 2021. There was a dip to the 3% percentile in October, which is right around the time that the petition was filed by the department. But I note that at that time, even though there was a dip, and I believe it was the October appointment, a few weeks later at the November appointment, the child was back gaining weight and back to the 5% interval and gaining weight appropriately. And I note that it's significant that there were several factors that the doctor said contributed to the child's low weight gain. The genetic makeup, vomiting, that were not attributable to the respondents. And I further note that there was evidence that both parents were calling the doctor's office regularly.
Let me interrupt you just for a second. You're saying that the vomiting was not attributable to the parents. Wasn't there some allegation in the record that the parents were not feeding the child with proper formula and were feeding the child with, I'll call it whole foods, as part of the diet, and the doctor was trying to clarify to them that they shouldn't be doing that, and that may be causing the vomiting?
There was allegations of that, but I believe both through the testimony was that the parents wanted to provide soy, that they were concerned with what was being provided. And I think once the change was made, it wasn't until that October pediatric appointment. And at that point, I believe that they were following the recommendation at that point, even though they were calling, asking if this is still the right case. And I think at that point, the doctor said, we're going to schedule the GI tract study and go to that appointment. I believe there was testimony by the doctor that until that study was done, he couldn't rule out what exactly was causing the vomiting, whether it was what the child was being.
And that GI tract study was scheduled, right?
It was scheduled, and then.
And the child didn't appear.
That is correct. Although my clients did, the respondents did cancel that appointment and did give a rationale saying it was too cold outside. That wasn't really explored thoroughly at the trial level.
Was it explored enough that a witness testified that the child was seen outside in the cold with one of the parents that very day?
Yeah, but I believe there was also some testimony about whether or not it was actually cold, if it got warmer during the day. I mean, it was kind of a little bit gray as far as what the temperature really was, and if in fact it really wasn't a good reason for canceling the appointment.
But this is a good question. The father didn't testify in this case, and the court took a negative inference. Was that appropriate for the court to do that, and what impact do you think that might have had on the determination?
I think in this case, I don't believe that I'm arguing that there wasn't a prima facie case made out initially, which would require either of the respondents to rebut that presumption. But as a result of that, yes, I believe it affected, obviously, the outcome in this case. And ultimately what the child court decided. But I believe that there's enough there based on the doctor's testimony alone, that there was other factors contributing to the child's low weight, that the parents were doing things, that they were going to appointments, they were calling the office, making inquiries. I don't believe that just the one incidence alone of, possibly not following the instructions or canceling the GI study is enough to establish neglect in this case. Unless the court has any other questions, I'd ask that the trial court's decision be reversed and the petition dismissed.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Deanna Terry with the Oneida County Department of Family and Community Services. I would disagree with the appellant's assessment of the evidence in this case. The trial court properly held that the appellant neglected the child. Expert medical testimony established that the parents were failing to properly feed the child. This included mixing the formula incorrectly, giving whole foods, giving soy formula even after a milk allergy was suspected. However, I don't think it was just about how they were feeding the child. I think overall, all their behavior exhibited to the doctors and the caseworkers repeatedly exhibited they could not understand how to feed the child properly. They were not understanding the seriousness of the problem. That became the critical issue when the vomiting began. At that point, the parents had already repeated that they were not mixing the formula properly. The child had gone from the 5th percentile to the 3rd percentile. The child never regained to the 5th percentile, but did start gaining again. The problem was the child being at that low weight was at a high risk for poor brain development. He had no problems when he was born with muscle tone or any identified problems that would cause weight gain. But he was showing signs of delayed motor development. He was not even sitting up properly. He was having other issues. The doctor testified that that could be caused by poor nutrition, and absent any other evidence of another problem, I think that's what the doctor came to, that was the cause for that problem, which would show that he was having problems with brain development.
Counselor?
Yes.
In reading Dr. Chung's testimony, it comes across as he was utterly frustrated at the parents' inability and or unwillingness to properly prepare the formula, to not give the child regular food, and not being consistently, albeit somewhat in contact, but not consistently so, for the GI visit. And one thing that caught my attention was, didn't the doctor testify that the chronic vomiting that the doctor had diagnosed, if not cured or stopped, would very likely contribute to possible SIDS, something like that?
I don't recall if he said SIDS specifically. I think he may have, but he did say one possible risk was death. But beyond that, even if death was not caused, the vomiting reasoning needed to be found out immediately. That's why a GI study was scheduled very quickly. And I think anyone who goes to a medical professional knows that you can't often get in right away anywhere unless it's serious. It was serious to the doctor. They called and they gave the excuse it was too cold to come out. And I think it was only about an hour later, if I'm correct, that they were seen outside the office with the stroller. So I don't think the temperature had changed that much. And at that point, the doctor assessed the situation as being so risky that the department had to come in and remove the child just to get that done. And the vomiting was also, that's why even after that, they were saying that they were still insisting on feeding the child soy. With a milk allergy, that would have caused more vomiting, which increased the risk. Overall, though, I think it was the totality of the circumstances. The feeding was part of it, but their behavior, their insistence on doing things the medical professional said would be risky. Even when the caseworker went to the home at the time of the removal, the mother was still giving the wrong ratio for the formula. They were citing things, I think, in the record that some of the child's problems were due to a haunting. All this together, their demeanor during the proceedings, all led everyone to believe they really didn't understand what they were doing to care for this child. And apart from the feeding, I would like the court to note that there was other testimony regarding domestic violence in the home, the child's general condition as observed by the manager of the property, the housing condition, which was labeled as disgusting once they moved out. They just did not seem to understand the seriousness of the situation or what the child required for adequate care.
Thank you, counsel. Anything further?
Nope. Thank you.
Case 913 in the matter of Adam B. Okay,
Good morning.
Hold on, counsel, I'm sorry. Just 1 second. Counsel, can you let us know whether you can hear us or not?
Good to go, Your Honor. Thank you.
Very good. We can hear you loud and clear. Counsel, thank you. Sorry for the interruption. Proceed.
Good morning, Your Honor. May it please the court, Joseph Jarzembek for the appellant, Darrell P. Your Honor, this is a case that's for this court under Section 1012 A, B, and G that is controlling, or that statutorily is the important where we start with this case. It is our position that my client, the appellant, was not a person who, under the statute, was legally responsible for the care of this child. He's not the biological father. It's my contention that he's not even the boyfriend. He may have been a paramour of the respondent mother. He did not live or reside with the other two respondents, and it's our position that the department in their petition had a defective petition because he wasn't a party that could be charged.
Counsel, I'm going to ask you a question, if I can, and it's similar to, I think, one of the last cases. Your client failed to testify in this case, correct?
That's correct, Judge.
And the court's allowed to take a negative inference and did in this case, right?
That's correct, Judge.
Okay. What impact does that have on the court if the judge can take a negative inference relative to your client not testifying?
Well, before the court even drew the negative inference in its decision, the court said, quite frankly, that it was struggling as to what my client's responsibility. The court said in its decision that he didn't have a fleeting connection on one hand, and on the other hand, the court did not say that he reached the level of a functioning level of a parental substitute or person legally responsible. So it's my position that the court doesn't even get there because the court doesn't even have that. Secondly, and I know there are cases that, we're bound by the Court of Appeals decision in the matter of Yolanda D. it's not an old decision, but it goes back from the 90s, and it has been interpreted by this court in various decisions. I would note, however, that in some of the cases, in fact, some of these cases can be distinguished from my case. One of the cases that's cited is Heavenly A, which is a relatively recent case. It was 2021 from this department. But in that case, you had a situation where the court drew what I call, in fact, the language that's used in the decision, a very strong negative inference, because the person didn't show up in court, the person was actually residing with the mother, and the person in that case was also identified as a resource either at a school level or at a hospital level. My client does not have that connection. He is not the father. If he's had a relationship, it's been very short-termed. He doesn't, it was clear when the caseworker went there that there was no bassinet, there were no other baby supplies that were at his residence. He has identified himself as residing at a house on Shumway as his apartment. It's unclear. Mom was bouncing around with her grandmother in one apartment, then in another apartment, then I don't know whether she had a room in a house or whether she was...
But didn't she say that she stayed at your client's house at least 2 to 3 times per week in his house, her and the child? And this child is only 3 months old.
We have a very young child. That was, there was an objection. I don't know if that was the point where trial counsel objected to that coming in as hearsay, or whether from a co-respondent, which then leads to an issue of whether that can be considered for purposes of credibility of the witnesses. So it would be my position that the department did not, and like I said, the judge in this case had to draw the negative inference, and I think it was a much more stronger negative inference, like some cases, because it wasn't a case where my client wasn't in court, or I should say, my client currently, and he was present throughout the proceedings. And I think that because the trial court had a problem, making that distinction, the court thought she wasn't sure. She was in the middle of where she could go with this. So I think to make that...
In terms of how this played out, though, the judge gave significant warnings about the negative inference before the grandmother testified, right?
The judge definitely gave negative inferences.
Before.
Yeah, before and my client was aware of that.
Right. Then the grandmother testifies, and the grandmother considers your client to be the primary babysitter, I think was her words. Is there anything that prevented your client from taking the stand at that point to dispute that?
I don't know, Judge.
Okay.
But your client admitted that he cared for the child, that he was babysitting the child. Didn't he himself admit that?
He made some statements, but I don't know if they were, But like I said, the court, even with those statements, had problems making a decision, and I think that the court respectfully overreached using a strong negative inference, which I don't think the court should have done in this case, to make my client legally responsible.
Counsel will take a look at that.
Thank you very much for your
Thank
time
you,
and
Counsel.
consideration.
Counsel?
Good morning. On behalf of the Erie County Department of Social Services, Benjamin E. Mannion. Your Honors, there were just just one point I really wanted to touch on, and that goes to appellant's argument that he was not a person legally responsible. As the case law is made clear, and I know appellant's brief hammered very hard on the in loco parentis argument, and here before Your Honors this morning repeats that argument that appellant does not meet the definition of a parent or a parent substitute. In reality, he does not need to be a parent substitute. He just needs to be an individual who is found to be, paraphrasing, caring for the child at regular intervals, which the testimony at trial did demonstrate before we even got to the negative inference, or before the trial court did, that Mr. Peoples was regularly, at least 1 to 2 times a week, seen with the child, took care of the child, and even in the week in which the injuries were likely to have occurred, according to medical testimony that came out at trial, Mr. Peoples was admitted to, or the other respondents admitted that he had cared for the child on at least one of those days while the respondent mother, Miss Lynch, was at work. Therefore, it's the department's position, as the trial court found, that the evidence elicited at trial demonstrated, in addition to the negative inference that was correctly drawn, that appellant was a person legally responsible. Appellant is not contesting that the injuries occurred at this time, does not argue that point whatsoever. Therefore, the department did make a prima facie case, and as to the rest of the papers, the department would just request that this court affirm the decision of the trial court. Thank you.
Thank you, counsel.
Good morning, Your Honors. I'm Melissa Cavanero on behalf of the child, Adam B. The lower court was absolutely correct in finding that Mr. Peoples was a person legally responsible for the care of my client. He took a role in this child's life that is more than a fleeting place. He admitted to the caseworker that he cared for my client in the relevant period of time where these very, very significant injuries occurred. These are not minor injuries. This is a shaken baby. He admitted to the caseworker that he was there. He admitted to caring for the child. The other two respondents admitted that he played a significant role in the care of my little client. And Yolanda D. is very, very clear that Mr. Peoples falls within a category of being the person legally responsible. Justice Ogden, you had asked appellant's counsel about the maternal grandmother's testimony. She testified that the mother and the respondent, appellant, resided together, and that he did care for the child, and that the respondent admitted to the caseworker that he cared for the child. The lower court gave the appellant two separate, very, very stern warnings on the record that if he failed to testify, that they would draw the negative inference, which they are allowed to do. The case law is very clear, and given the totality of all of the testimony of the parties, including two well-respected medical doctors, the lower court was proper in making their decision.
How is the child now?
He is good. He is placed in Article 6 custody with his biological father, and he has made almost a full recovery from all of his injuries.
Thank you.
Thank you.
Case 914 in the matter of Landon F. Counsel, proceed.
Oh, thank you, Your Honor. I'm representing Jody G. in her appeal from the termination of parental rights order on the basis of mental health and mental incapacity to care for Landon F. My client's, I think, arguments come under two branches, the first of which is that she does not view herself as being mentally ill. Her position for that would be first and foremost is that DSS, she does admit that she has disabilities, and that DSS did not accommodate her disabilities pursuant to the American with Disabilities Act. There was also a mental health, and one point which I made in my brief, Your Honor, was the anxieties that she has, as Dr. Nathans had pointed out in his testimony, that having a child removed from your custody does indeed cause anxiety. So all these mental health issues that she presented, were they the cause of the removal of Landon, or were they the result of removing Landon? I mean, why was Landon removed to begin with? And that she was meeting Landon's basic needs. She was, admittedly, my client does prescribe to a lot of the alternative theories concerning organic meals and whole foods, and she was feeding Landon meals along those lines. She was also seeing to his basic hygiene. So that's why the first branch would be is that my client does not really meet the criteria of mental illness, and even if she does, she wasn't. Landon was not in danger of being neglected by her, and that.
Counsel,
yes.
Did she raise the issue? Dr. Nathanson made a determination that she suffered from mental illness. Did she ever challenge that in any way, his qualifications specifically?
Well, I'm glad you asked me that question, Your Honor, because that leads to number 2, the ineffective assistance of counsel, that, you know, when I said with an ineffective assistance of counsel, that trial counsel never asked the court for an independent, for his own evaluation of Landon, of Jody. And, you know, Jody describes Dr. Nathanson as the, quote, hired gun for the department. And I said back to Jody, if that's the case, then where was your hired gun? I mean, why didn't trial counsel, as you know, ever go to the court and say, you know, can we have another psychiatrist or another PhD psychologist examine Jody to verify Dr. Nathanson's, and I see this all the time in this type of a case where the respondent never thinks to ask for the court, we need our own expert to examine Jody. So Your Honor, I guess to answer your question more directly, there was never an independent verification.
But is that issue preserved?
Well, I mean, you could preserve it in terms of weight of the evidence, and you could get it in under an effective assistance of counsel.
But
But
when we look at ineffective assistance of counsel, one of the questions becomes, was there a demonstration in this particular case that there was an expert available to be called, right? Because if there wasn't an expert available to be called, then there's no ineffective. You'd agree with that, right?
Well, I would agree up to a point, but then did Mr. Harrington have the obligation to ask the court for that expert to be appointed? There was some dialogue.
Let's assume for the sake of argument that the counsel at the hearing should have asked for an expert and didn't. And that's the claim for ineffective. In other words, let's assume that he should have done that, failed to do it, and that's your argument that the court only had one expert and it was contrary, given opinion, that expert, Nathanson was given an opinion contrary to your client's interest. Assuming that's the case, still on an ineffective, when you're before us, you have to demonstrate, do you not, that there would have been an expert available had the attorney looked for one. Because what if the attorney looked for one and couldn't find one? Because that happens too.
Well, he could have called Dr. Demarath. I mean, he could have had Dr. Demarath examine her. He's done forensic interviews in these types of cases. So I think there was one available.
So help me with the record then. Is there something in the file that indicates that Dr. Demarath would have rendered an opinion contrary to the opinion by the petitioner in this case?
No, we never got to that point.
I mean, so in other words, what you're saying is counsel, there is an expert out there counsel could have talked to. My point is, what if counsel talks to an expert, which we have all the time here, where they couldn't find an expert that would contradict the petitioner's counsel, or expert?
Well, had he gone to Dr. Demarath or any PhD psychologist and they examined Jody and Jody came back with the same opinion, then okay, well, then that might be a different result. Then they obviously don't call that person. But it's certainly the issue, I mean, certainly the request should have been made to at least see who was available. So, I mean, it was never really formally presented to the courts. So whether it's preserved in the strict, Section 5511 CPLR sense of the word, or the more broader, we could just look at the record and let the record speak for itself. I mean, that would be for the court to decide. But I think you also point to other elements of ineffective, like playing the percentage game that only 1% of the people are delusional. If that's the case, there are 15,000 delusional people in Erie County. So saying that she's not delusional based on statistical is not exactly an argument that helps her cause. And so I'm going to go down to some of the other examples we can give, that the brief gives. But though I think it also, the idea of bringing Judy Mikovits to the stand, I mean, she's a biochemist, I don't think that would have really helped her cause, given her own background, and so.
We'll take a look at that.
Oh, thank you, Your Honor.
Thank you,
Any more
Counsel.
questions?
Good morning again. I am asking this court to uphold the decision of the lower court. The lower court was correct in finding that the appellant did have significant mental illness that rendered her ability to care for my client. She was diagnosed with a slew of mental illnesses. even notwithstanding her disagreement with the diagnosis from Dr. Nathanson, there were 2 objective mental health tests that were provided to her, the Stanford-Binet. And she scored very, very poorly on the Stanford-Binet. She also was unable to complete the MMPI-2. It took her 5 hours. She couldn't answer simple yes or no questions. When discussing how the court has harmed her and why she has mental illness, she was non-responsive or nonsensical. At one point, she said that the court gave her cancer because of the stress. She was still holding on to the fact that she believed that my client had autism when that was ruled out in 2018. She had always really had difficulty caring for my client and was in no better position at the date of the hearing. I would say that counsel for the appellant went over and above to make accommodations for her, to temper the strong mental illness of his client, and he did her significant service in this hearing. The facts are the facts, and it is what it is.
I just have a question about why there was no dispositional hearing. When this child has been in 9 to 10 different schools, 3 to 4 different placements,
And so, Your Honor,
let me hear your argument on
the attorney
lack
for
of a
the
dispositional
so it was
hearing.
well within the court's discretion to reach that decision. It is discretional. The court in this instance declined not to have a dispositional hearing. The attorney for the child at the hearing strongly requested a dispositional hearing. I am not taking that position today based upon where my client is. He's in a pre-adoptive home. He is doing well. At the time of the trial, his situation was very, very different. It's possible that given the facts, the court should have held a dispositional hearing. It, again, is discretionary, but as we sit here today, I am not in favor of any sort of remand for a dispositional hearing. My client, his barrier to permanency is the decision of this court.
He's in a home and no longer in the group home?
Correct. He's in a
common facility?
pre-adoptive home. They are ready to adopt. They're just waiting on the decision of this court.
Thank you, counsel.
Thank you.
Case 915, Stefanski versus Huntress. Proceed, counsel.
Good morning, Your Honors. May it please the court, Leah Costanzo for the plaintiff appellate. I'm going to start with our third prong of the argument that the defendant's motion for summary judgment never met its initial burden. Defendant submitted no evidence to establish that they were entitled to summary judgment relative to David Stefanski, as no evidence was submitted as to what conduct, if anything, he endeavored during the accident. There is a complicated procedural history which we set forth in our papers relative to our expert's report and why it should be considered. Our position is that Mr. Harrington's report should have been considered and that he was waiting on an imperative piece of factual evidence relative to one single witness who previous to, in the police investigation, indicated that she had witnessed the accident. All of the parties, including the 2 other companion cases, were seeking her testimony. The court did extend the time for us to get a statement of that witness. We did get the statement, and the witness did provide new information. That information was provided to the expert, and he then rendered a report, which was submitted to the court. The court declined to consider the expert's report and indicated that even if he did consider it, that it was speculative. Our position is that it was not speculative. The expert goes through exhaustive lengths to establish speeds, distances, reaction times, and actually uses a test that is used routinely with accident reconstructionists to establish what Mr. Stefanski did or didn't do at the time of the accident. And in this case, the indication from our expert is that a normal person would respond and react to the accident within about 2 seconds. He didn't respond at all with over 4 seconds, and that he could have taken. Yes, sir.
Thank you. The witness that you're talking about, that you got a statement from, that's the former girlfriend of the driver behind the, was it a Toyota Civic?
Yes.
I'm not sure the model of the car, but in any event, she was in a minivan behind him, kind of following him the whole way. And it's my understanding that the statement she gave was somewhat contradictory to the prior statements that she gave the day of and the day after the accident. But in a couple of respects, she did give additional information. One was that the driver, the boyfriend in front of her, had been weaving for a mile before the accident. Is that right?
That's correct, Your Honor.
And there was a second, I think a second piece, but now I don't remember. Was there something else that she added in the statement that you had that the expert was able to consider?
She was approximately she testified, or she put in her affidavit that approximately from the time that he crossed over the double yellow line was 1 mile before the impact occurred with the first motorcycle. And the Stefanski motorcycle is the second motorcycle that was driving behind the first motorcycle.
Right. Right, and I think she also said in her later statement that there were no cars in between her and the vehicle, so that she had more of like a bird's eye view of what happened.
Correct.
Although there was something about a hill then, and she couldn't quite see it.
Was there also something, and correct me if I'm wrong, something about the girlfriend trying to get his attention because she wanted him to maybe pull over and not operate the vehicle? Was there something in there?
Yes, Your Honor. She had indicated that she honked her horn at him to try to get his attention. I think actually in the record it establishes even that the huntress he had applied the brakes before our client even applied the brakes, even though he was asleep at the time of the accident with respect to her horn. The two supporting depositions that she gave in the police investigation indicated not specifically what the totality of the circumstances and what the motorcyclists were doing, but that she witnessed the accident, and that at one point even one of the individuals riding on the motorcycle were flying towards her vehicle, that she thought she was going to get hit. And then when we sought the testimony of Ms. Waldemarson, she indicated that she really had no recollection that she was cresting a hill and that the accident had already happened at that time. We had no reason to anticipate that she would have changed her testimony or failed to add anything with respect to Mr. Stefanski, which was the subject of the motion. And I would just notate the Summer Eve versus Plaza construction case where we're entitled to get any discovery that would aid in establishing what happened in the accident. The court permitted us to get the discovery, but then failed to consider it. And I think it was reasonable for our expert to expect to have a full and complete record, specifically with respect to the single witness to this subject accident under the circumstances.
Okay, thank you.
Thank you.
Good morning, Your Honor.
Proceed, counsel.
Jonathan Dominic for David Stefanski, defendant respondent. If I could address the plaintiff appellant's second point first regarding the consideration of the SIR reply. Although that's not how the plaintiff appellant identifies it in the papers, practically speaking, it's what it was. The trial court properly refused to consider the SIR reply for two clear reasons. First, it's a discretionary determination within the trial court's purview, and SIR replies are generally disfavored, as is detailed in the cases cited by both parties. The cases that are cited give a range of situations where SIR replies are considered. They find that sometimes courts are within their discretion to consider SIR replies. That's within the plaintiff appellant's cases at U.S. Bank and Indiana Harbor. The cases that we cite are instances where a court within its discretion refuses to consider a SIR reply, be Grafio, Pinkow, and Gluck. And there are also some cases where a trial court does consider a SIR reply and the appellate division finds that considering it was an abuse of discretion. That would be in Flores, Romeo, and Booklore. And generally speaking, those are when there is no good cause for the trial court to consider any supplemental documentation.
In this case, the judge was somewhat preoccupied with the fact that discovery hadn't progressed the way that he had ordered or that he and a prior judge had ordered, right?
That's correct, Your Honor. This case had been a protracted litigation with multiple scheduling orders previously issued under Judge Clark, one under Judge Sedita. And the specific timing of the scheduling order, the deadline of discovery under the scheduling order is extremely relevant here. April 15th was the deadline by which all non-party depositions were to be completed. That was the term within the scheduling order. the deposition of Ms. Waldemerson, which...
But there was a later date to compel discovery, a later deadline.
There was, within the initial scheduling order, there was a time after that April 15th date for motions, pre-note of issue motions, and the note of issues were to be scheduled, filed within a month.
But those motions could have included a motion to compel discovery, so that if you were trying to schedule a deposition like in this case, and in fact it had been scheduled, but it couldn't be scheduled before the deadline, there still is an opportunity to move, even under the judge's existing order, an opportunity to move to compel the discovery saying, gee, we have this one final witness, this witness who was right there with a bird's eye view that we've been trying to depose, who's no longer in a relationship with Mr. Huntress. We'd really like to depose her. You know, you don't think that's a sufficient reason to at least then consider a surreply when the judge denied the deposition?
Respectfully, Your Honor, no, and I do not believe that's what Justice Sedita intended with the scheduling order, because the language of the April 15th deadline was that depositions were to be completed or would be deemed waived. And so even just looking at the language of the scheduling order, a motion filed after April 15th for that sort of deposition would not be permissible because the deposition would have been waived having not been completed by the April 15th deadline. And although I can't speak authoritatively for Justice Sedita, I believe the other discovery issues that could be the subject of those pre-note of issue motions. With regard to considering the surreply, the strongest argument that the plaintiff appellant can put forward is that the trial court had discretion to allow a surreply if it so chose, but of course, in this case, it did not, and that is also fully permissible within the court's discretion. And in considering whether there's good cause and what the trial court was considering, the plaintiff appellant identifies the plaintiff appellant misstates three findings of the trial court as it relates to the surreply. On page 3 of their reply, plaintiff appellant claims that the trial court admitted that it was a mistake to schedule the summary judgment motion for the same day as the discovery motions. That is not what the court stated. It's on the record at page 17. What the court noted was an error was that the oral argument for summary judgment motions did not occur on the same day as discovery motions. Based on that, the court did intend to hear all these arguments simultaneously. There would have been no subsequent oral argument date, no additional time for additional statements to be considered or obtained. All of this was supposed to be considered on one day, but due to a scheduling mistake, rather, it was not. Second, the plaintiff appellant at page 8 of its reply states that the trial court attributed the ongoing delays solely to the plaintiff. And that is simply not what was in the trial court's record. The court, as Your Honor noted, took issue with the protracted litigation as it stood, the numerous scheduling orders that had been ignored by the parties collectively, and for that reason, there should have been no expectation that the court was not serious with its April 15th deadline to complete all depositions. And finally, on page 22 of its initial brief, the plaintiff appellant claimed that the court did initially allow surreplies to be submitted, but then subsequently withdrew that allowance based on a statement or an email by the law clerk, Kristen St. Mary. That is also inaccurate. The law clerk was very clear, and the court clarified it even further in its order. The parties were allowed to submit filings, but there was no guarantee that the court would consider any surreplies that would be based on the substance of the submissions, and of course here the court found them to be unavailing.
Mr. Dominic, be mindful of your time.
Yes, thank you, Your Honor. Regarding the burden that the defense attorney has, the standard here, and we agree, is that David Stefanski would have to show that he was free from fault, but he can demonstrate that by a much lower preponderance or a much lower standard than the plaintiff appellant is claiming. We cited to Hillman and Ross, two Fourth Department cases, or at the plaintiff cites to Ross. In both of those cases, it's a similar crossover case or a left turn case, and the movement is able to establish freedom from fault by simply demonstrating that a car suddenly entered its lane or its area, and that is sufficient to shift the burden, even without any additional facts. Similarly, in the other cases cited, Frantangelo and Cooley, these are situations where the testimony shows the movement had foreknowledge. In Frantangelo, they saw the vehicle a half mile away swerving across the road and didn't respond. In Cooley, same thing, a left turn that they refused to, or the move-in did not slow down or take any response to. Here, there's clear testimony from the one person who clearly remembers the accident, the plaintiff, Minerva Stefanski, that it all happened very quickly, that it happened so fast that there was nowhere to go once Huntress' vehicle fishtailed and blocked off the road, that David Stefanski had no time to react, and she could not recall anything that David Stefanski could have done to avoid the accident. All of that must, at a minimum, establish a prima facie case to summary judgment and shifts the burden to plaintiff who was unable to raise a question of fact because their expert was not able to raise any specific claims of what David Stefanski could have done wrong. It was conclusory and had no specific scientific backing on it in the initial affidavit.
Why shouldn't we recredit the 4.6 seconds of reaction time in the driveway that's plainly shown in the video, or in the photographs, rather, that's attached to the expert report, the driveway off to the right, like a bailout location?
I believe, Your Honor, that is attached to the supplemental affidavit, which would be part of the SIR reply, which is our position the court should not consider at all, as the trial court chose not to consider it.
So your entire argument then hinges on the fact that we have to not consider that expert report?
Not entirely, Your Honor. The plaintiffs, as the trial court found, the plaintiff Minerva Stefanski's statement that there was nowhere to go and no time to react and impossible to avoid situation would be the most accurate, reasonable response that a driver could have, which is, of course, the standard when facing an emergency, a sudden emergency not of one's own making. However, the standard is certainly easier to meet when the supplemental report is not considered, which would be the appropriate standard for this court because it's an impermissible SIR reply. And touching very briefly on the claim that Mr. Harrington needed this expert affidavit, expert non-party deposition, Ms. Waltzman is not the only witness to this accident. In addition to Ms. Stefanski, there are two additional witnesses listed in the police reconstruction, Mr. Prush and Ms. Brunner. Their statements were never obtained, their depositions were never sought. So the claim that Mr. Harrington needed the deposition of Ms. Waldmanson and could not possibly issue an expert affidavit without it is simply false. He did it once it was clear that the deposition was not forthcoming, and he had no interest in hearing from two of the other witnesses.
Counsel, you should conclude.
Thank you, Your Honors, and if there are no further questions, I appreciate your time. Thank you.
Thank you. Case 917 and 918, Trist versus Nixon Equipment Services, Inc. We have one counsel appearing by video.
May it please the court, Your Honors.
1 second. Let's make sure that we have everybody here. Mr. Scott, can you hear us?
Morning, Judge. It's Michael Sullivan appearing on behalf of Robert Scott.
Okay, very good, Mr. Sullivan. Thank you. Please proceed, counsel.
Oh, thank you. I appreciate it. The court below dismissed this case, dismissed plaintiff's cause of action on 240 under the labor law, based on 4 grounds. We believe that dismissal on all 4 grounds was error. First, the court below found that the structure involved here, an alignment jack, is not a structure. The plaintiff's position
Counsel, would you get behind the podium, please?
Certainly.
I know that trial lawyers like to wander, but here we've got you, we're capturing your argument on video,
very
the
good.
live stream. So
Very
please,
good.
Please stay there.
My apologies.
Thank you. Proceed.
The court, in doing so, and deeming that the alignment jack was not a structure, disregarded the very clear definition of what a structure is and what it constitutes under the Lewis Moores versus Contell of New York case. I don't think there's even a dispute among the parties that the alignment jack was a structure. Number 2, the court says that because the injury did not occur during the course of the repair, Section 240 doesn't apply. But that, again, is to disregard the Pratt's decision and its progeny. Most recently, a case decided by this court, the St. versus Syracuse supply case.
I'm sorry, I'm acting like I'm going to interrupt you, and I know that it's
that's
halting your
okay,
argument. They're not climbing on. They're not climbing or going up the alignment jack. Alignment jacks is just a unit that's being unloaded from a truck, right?
Well, I think the point that plaintiff makes here, Your Honor, is that what is the repair process? It involves more than just the actual repair, the alignment jack itself. We allege, again, asserting that the case is similar, if not identical, to the theory set forth by the Court of Appeals in Pratt's and by the Fourth Department in the same case, that the repair here constitutes more than just the actual repair. It involves the defendant going to the automotive shop, disassembling the alignment jack, loading it into his van, taking it back to his place of business, doing the repair, bringing it back to the automotive shop, unloading it, and then reinstalling it.
I thought at the time of the accident, there was just two guys unloading a truck.
They were unloading the alignment jack.
Right.
And the alignment jack was...
The alignment jack would happen to be the piece of equipment, but it could have been anything. It's a 200 to 300 pound piece of equipment they're unloading, and the one guy hurts his arm in the process, the plaintiff. But we have cases, labor law 240 cases of people unloading trucks. Like that's sort of one subset, right?
Well,
and why shouldn't we just follow those cases?
Well, because this is, plaintiff contends that this is within the context of a repair. Those cases are simply an entity, a plaintiff dropping off equipment or material to either a construction site that has not yet begun construction, or to like in the St. case, a site where nothing has occurred. The construction may occur sometime down the road. But this was an ongoing repair. The jack had been brought back and had been reinstalled.
So, counsel, let me interrupt you just to kind of follow up on Justice Nowak's question. So you're saying, would you say that if this was just the unloading off the back of a truck, then it's not 240?
Perhaps.
In order for us to get there, we need to look at the totality of the work that was being done and see where this material came from and where it was going to once the repair was done. And by looking at the totality, it does bring it within the 240 realm.
Exactly so, that this was work ancillary to the repair or part and parcel of the repair itself. Third, the court has determined, or did determine, that the defendant was not a contractor and an owner. Well, clearly the defendant was. The defendant contracted with Uptown Automotive to repair the jack and had total control over the repair process. Not just the repair, bringing it back to the defendant's shop and actually, doing what it needed to do, that is, I believe, replace the seals in the cylinder of the alignment jack, but to control the process where he retrieved the jack, loaded the jack, which required some assistance, bringing it back to the shop, doing the actual repair, bringing it back, needed assistance again. He expected assistance from the plaintiff's employer, as he had done in the past. This wasn't the first time that he had taken such equipment to and from Uptown Automotive, and it wasn't the first time that he required assistance in either loading or unloading a piece of equipment like the alignment jack. He expected it. That is, Mr. Nixon expected it, the president of the defendant, and he testified to exactly that expectation. So clearly, because the defendant had control of the repair process itself and that he'd entered into a contract, as he had done many times before, for repair of a structure, 240 should apply. And then finally, and I think this is the point we already touched on, the court found that this was simply a delivery of equipment. And we disagree with that assessment or characterization, that this was part of the repair process itself. Now, the court also dismissed the general negligence claim brought by plaintiff. And it dismissed it based on the
200 and common law fall and rise together.
Correct.
And your point, if I understood it correctly, Mr. Seeger, is along the lines of the contractor there is at a minimum an agent of the owner, and your client is the employee of the owner, and he's the only one there, and the guy needs help to unload this thing, and it was clearly under the direction of the defendant as to how this was to be performed and how to do it.
Precisely so, Judge. This isn't as if the...
You may not win on that basis, but you're saying it's a question of fact. I'm sorry to interrupt you twice.
No, by all means, I hope I'm well-centered here, but in every respect, literally and figuratively. But the point is exactly that. This isn't as if defendant went across the street and asked some bystander for help, or some bystander simply came to the aid of the defendant. No, this was an activity that was consistent with past activity, and there was a very strong nexus, as you appropriately point out, Judge, between the defendant, between plaintiff's employer, and between plaintiff's co-workers in the past, that they were part and parcel of this repair. That's all I have, unless there are additional questions.
No questions, counsel. Thank you.
Thank you.
Sullivan?
Yes, thank you, Judge. I just want to very briefly get right out there the issue, the fact that what happened to Mr. Treist on the day of this loss was absolutely not a violation of Labor Law 240. It didn't qualify as a special risk in that it didn't involve a fall from an elevated height of an individual, or that something that was an object being hoisted was improperly secured as it was being hoisted and fell upon the plaintiff. This is simply a plaintiff who, by the way, and no word was mentioned to this by counsel, he volunteered. He knew exactly that he just came to this, Mr. Nixon came to the store that morning. Mr. Treist was there. He had asked for the usual person to help him move.
Mr. Sullivan, you don't really need to win or lose on the volunteer, because couldn't at least an argument be made that if the plaintiff hadn't helped out to get this equipment into the employer's place of business where the employer presumably needed it, that the employer would have been pretty unhappy with plaintiff not helping defendant unload this for the employer's benefit. Isn't that a fact that a jury could consider that counterweights the volunteer argument?
It may, Your Honor, but just as a matter of law, I believe the fact that Mr. Treist was so willing to volunteer, and he had never done this before, and he was actually asked 3 times, are you sure you're going to be able to do this? And he says yes. I think that's part and parcel to what has happened on this particular accident.
Counsel, I think we have that part of your argument. Do you want to move on to anything else?
I want to just stress the point that this is not an elevated height risk. He just injured his arm lifting a heavy weight. I also want to stress the point that
Nixon, so you don't think this is one of your opponent's arguing this is the totality here. We can't segment this out. We can't break down each step of what's taking place here. And when we look at the totality, he says this is part of a process that involves a repair and moving this structure, this equipment, from one place to another, repairing it and sending it back and reinstalling it. If we don't segment it, would you agree that this does fall under 240? But if we do segment it, it's another case of pulling something off the back of a truck, many of which we've already had.
I think if you segment this, as counsel has said, I think you still make the argument that it does not qualify as a 240 case. And the reason why
elevated height issue?
Elevated height issue, my client is not a contractor and owner. The argument could be made, and I understand there may be issues on it, but I think there's a strong argument to be made. These casters were just worn and torn. It just had to be replaced in the ordinary course. They were not damaged. As for direction and control, there was no supervisory direction and control at all. There was no game plan saying, here's what you're going to do, Mr. Treist. This is the way it's going to be done, and I'm going to show you, and you're going to do this whether you like it or not. That's not what happened here. This was just a slight elevation. A man injures his arm because of the weight of the hoist, and my client is not supervising the work at all. He's not a contractor, and I believe that the lower court in granting summary judgment to my client on 240, 200 and general negligence was proper and should be affirmed.
Thank you, counsel.
Thank you.
Case 919, Jefferson County Director of Community Services versus Alexander J. We have both counsel appearing by video. Okay, we have you both on. Counsel, can you both hear us?
Yes, Your Honor. I can, Your Honor, yes.
And we can hear you. Please proceed.
Terrence Brennan for Jefferson County Director of Community Services. Morning, may it please the court. The appellant's position is that granting anonymity to this Kendra's Law proceeding respondent was unnecessary because of existing protections in both Article 9 and Article 33. Article 9 provides blanket protection by sealing the court record from view from everyone except the parties absent a court order. And the respondent has failed to provide any reason or justification why the Supreme Court should have the discretion to provide anonymity or pseudonymity based on unusual circumstances. Instead, the respondent stated that because they're a patient for mental illness, that would justify providing anonymity. That's true in any mental hygiene case. It's not unusual at all.
Any further, counsel?
I think providing this sort of blanket discretion to the court to anonymize a case based on general conditions, it gives the Supreme Court too much discretion to the point where it applies to as a general rule in each case. So it's invading the legislature's role of creating court rules. So that this case, I've heard that stated that anonymity is contagious. And I think it's true in any case, because as soon as the court says this caption will be anonymous, then I think all the parties start referring to it anonymously in communications. Other types of cases, like we're relying on the Amherst case from this court, Doe versus Amherst, that dealt with the child victim case. And now we have a mental hygiene case, not even following the rules of that case, but stating that in a general condition of mental hygiene treatment, that anybody who receives that treatment, the court should be able to anonymize the case. And as I said, is blanket protection. That means that if you search the person's name in court records as a guest in the system, it will tell you that the case is not available to you. But you have to ask the court to provide access to any non-parties in this kind of case. So if the court anonymizes it, it's not findable in the index. So the public cannot even find the case. It's more like a cloak of invisibility instead of a blanket. So by granting anonymity without any kind of justification that's fact-based, the court is removing it from the index effectively.
I think we have your argument, counsel. Thank you.
Thanks.
Counsel, proceed. Bob, you got to put your take your mute off.
Okay, I apologize, Your Honor. Good afternoon, David Agigian from Mental Hygiene Legal Service on behalf of the respondent. I submit to this court that this court's order in Jefferson County Director of Community Services versus Tad Am is dispositive regarding respondents' entitlement to anonymity in a proceeding under Mental Hygiene Law 9.60. It's clear that appellant believes that that is not binding on the appellant. Appellant is making the exact same arguments that were made just a month ago with respect to Tad Am. Chief among them is that this idea that there is that each respondent or patient in a mental hygiene law section 9.60 case has to be scrutinized on a case-by-case basis. The reason Doe and all of the other cases that appellant cites
are not relevant is that this is indeed mental hygiene law. And as we've stated in our brief, and as I stated, in oral arguments before, it is clear that mental hygiene law makes private all of the records of a patient. And as I noted, NTADM, and I'll note again, Section 33.13C of the mental hygiene law includes in the definition of private records the identification of a patient or client and clinical records or clinical information tending to identify patients or clients. So the fact is, the mental hygiene law has been in place to protect the identities of persons with mental illness, and this is under mental hygiene law. And so, your honors, what we're looking at here is what appears to be the intent of the appellant is each and every time there is an AOT case, an assisted outpatient treatment petition for an AOT order, appellant can come before this court and ask the court to overturn what the court below has decided with respect to this, and that's more or less what's happened. I mean, he noticed appeal, the appellant noticed an appeal in a third case, but has not perfected it. So there is a case out there, and then just most recently, he's filing these petitions for AOT as recently as last week with the full name, and it's clear that the presumption that exists in general criminal law or civil law doesn't apply here because of the statutory scheme of mental hygiene law. And therefore, Your Honor, I respectfully request that this court not only reiterates its determination in TADM, but expressly rejects the reasoning of the appellant.
Thank you, counsel.
Thank you.
Case 920, Lillian C. versus City of Syracuse. Counsel, proceed.
Good afternoon, Your Honor. John Powers. I represent the City of Syracuse, who's the appellant in this matter. With respect to this appeal, the city contends that the trial court erred by denying the city's summary judgment and finding that a negligent roadway design case could exist against the city for an intersection that was designed and controlled by the state of New York. I'm going to assume that you're familiar with the facts, but I think at the outset we need to discuss this court's decision in Lillian C. versus the state of New York, which it decided on June 30th of this year after this appeal was perfected. And of course, Judge Lemondola did not have the benefit of that decision when he issued his summary judgment decision. The rulings of this court in that decision impact the issues in dispute in this case. Now, why is that? It involves the same plaintiffs, the same intersection, the same accident, the same theory of liability. And why do I say that? In your decision on June 30th, what plaintiffs submitted to you as proof that they had a claim against the state was the affidavit of Mr. Surth, who's a design engineer. That same affidavit was submitted in this case as proof that the city also has liability for this accident. Exactly the same. In that affidavit, as you noted in your decision in June, Mr. Surth opines that the state's design, this 10-foot bullnose median, shouldn't have been there. It has a double yellow around it, that what the state should have done was put a turning lane in there for cars turning left onto Collingwood. That was what was at issue in Lillian C. versus the state of New York. That's also the same theory of liability in this case. Now the decision, your decision in that case, observed that there's two sources of liability with this type of claim. There's liability for the original design, but there's also a continuing duty. So just because it's safe when it's designed doesn't mean that the municipality with control over the intersection gets off. They have a continuing duty over time to monitor the intersection based on current traffic conditions. With respect to the first source of liability, this court found that that intersection was designed by the state of New York. It also affirmed Judge Rivera's decision that that intersection was reasonably safe in 1974 when it was designed by the state. That source of liability has been decided by this court in that decision. It's off the table. Plaintiff cannot in this action claim that the city designed the intersection, and they cannot claim that the initial design was defective. Those two issues have been decided by this court's decision in June. What was left in that case, and what this court found a question of fact on, was this second source of liability, this continuing duty. What this court held was that the state of New York held the continuing duty to maintain and review the safety of the design of an intersection that it controlled. Now, why did this...
Which is different than maintenance of it, because I think the city, the record reveals that the city did have play some role with respect to the maintenance of the area right there at the intersection, correct?
There's no question about that, Your Honor. The city, over the years, assumed the duty of certain maintenance activities, and it's clear in the record. They fill in potholes. They pave over the roadway.
Your point is that they don't change the design of the intersection, and did not change the design of the intersection, nor did they have an ability to change the design of the intersection.
It would be a perfectly adequate argument if a pothole caused this accident to argue that the city had liability.
Or if the maintenance resulted in a change in the design of the intersection.
Or if the application of asphalt on the surface of the road in some way caused this accident. That's not the claim. There's no evidence that's been submitted by the plaintiff that these maintenance activities caused this accident. You not only have to identify a duty, you have to identify a breach of that duty, conduct falls below the standard of care, and that that breach of duty caused the accident. All three of those things to survive summary judgment. The claim that went forward against the state relating to the design is that there was a question of fact as to whether or not there should have been a turning lane there, which would have increased the sight distance, prevented the accident. That's the state's responsibility. It's a design responsibility. So now the sole question that we're left with in this appeal, Judge, is does the city share that responsibility? Does the city also have the responsibility to monitor the design of that intersection, even though it's a state-controlled intersection? And the answer is no. The case law from this court, from the Court of Appeals, has already decided that. Miller versus Tuckles, Ledette versus Battle, Monica versus Jefferson County, Beaumont versus Smith. In each of those cases, there was a traffic control device on a municipal-owned road. In the case of Miller and Ledette, it was a town-owned road. It's a stop sign on the town road, owned by the town.
Counselor, can you hear me?
Yes, Judge.
What about Costanzo v. County of Chautauqua? How do you differentiate that case?
Well, counsel, we're going to adjourn, and let's take appropriate steps. Thank you. Okay. Okay, counsel, thank you for your patience. Please be seated, thank you. And continue. And
I know exactly where we are.
Excuse me, Judge Greenwood, are you there still?
I am. I'm here. Can you hear me, see me?
Yeah, we can. We're very good. Thank you. Okay, please proceed, counsel.
So at the time of the alarm, Justice Greenwood had just posed a question, which was essentially, what about the Costanzo case? Costanzo versus County of Chautauqua in 2015. Doesn't that support the plaintiff's version of the law? And indeed, plaintiff asserts that case for the proposition that the city and the state can possess the same design responsibility at the same time, merely because the city owns part of that intersection. It owns Burnett Ave. Now, if
Mr. Powers, but this city goes on, I mean, not the city, Mr. Williams goes on in his brief, and he claims that it's uncontroverted evidence that the city designed this intersection after it was constructed and before the accident. How do you respond to that?
well, I'm prepared to respond to that. I would also like to respond to your Costanza issue question as well.
Go
So
ahead.
however you want me to take those questions.
However you feel you can do it the best. Go ahead.
Okay, all right. So Costanza did not change the law as decided by this department in Miller, Ledette, Monica, Smith versus Beaumont. And it didn't say that it was changing the law. And we don't know why the court reached the decision it reached, but it kept the county in the case, because there's only one sentence in the decision that addresses that issue. But what we do have in the record is we have the trial court's decision. And it was the trial court's decision that was affirmed by this court in Costanza. It was Justice Dillon's decision from the County of Chautauqua Supreme Court. That's at 3092 and 3093 of the record. And Justice Dillon stated why he kept the county in the case. He stated as follows: the defendant concedes that a question of fact exists as to whether the county designed the intersection. This would indicate that summary judgment motion should be denied, because once a municipality undertakes a duty, it must perform that duty in a non-negligent manner.
There's no concession here to that effect, right?
Not only is there no concession, Your Honor, this court's already decided that the original design was safe.
As you've already argued.
It's off the table. So the reason why the county and the state were still implicated in Costanza is because the county designed the actual intersection. That isn't the case here. Costanza doesn't apply. If the court wanted to overrule all these cases, I believe it would have said so, and it didn't. All right, so let's talk about this quote-unquote uncontroverted evidence that the city, prior to the accident, quote-unquote redesigned the intersection. So that's a statement in the brief with no citation to the record. Okay? We address it in our reply. Again, what's the theory of liability? There's a bullnose median. It has a double yellow line around it. And that, instead of that median, there should have been a turning lane. That's the theory of liability. Did the city design that? The answer is no. The designs are in the record, 705 of the record, the 1974 design. You can clearly see the bullnose median. You can see the double yellow around it. You can see the absence of a turning lane. That is also depicted in the photographs of the day of the accident. The bullnose median's still there. There's no turning lane. The record has been that that design did not change between 1974 and the accident. That was the state's design.
But counsel, does the city have a duty to at least make proposals or propose alterations to the state when a period of time has expired and there may be a safety issue relating to the intersection? Does the city have that duty? Does Costanza state that the city has a duty?
So this court decided in Miller versus Tuckles that very question. Okay, whether or not the municipality who was relieved of the duty by the vehicle and traffic law still had a duty to warn the state. And the answer is no. But beyond that legal question, with respect to the factual question, the plaintiffs have already asserted to this court, they've asserted it in Mr. Surf's affidavit, that the city did ask the state about whether or not left-hand turns should be prohibited. In fact, Mr. Surf testified as a design engineer, and this court relied on that in its decision in June. He testified that had that discussion been had with him when he was working with DOT, he would have implemented a traffic study. Now, this court relied on that evidence and that submission by this same plaintiff's, same counsel. So even though there's no duty, no legal duty, I would also submit to you, they've already represented to this court that the city did contact the state about this intersection. And this court relied on it. That's a judicial stop. Now, back to the question of the quote-unquote redesign. I don't know what plaintiff's counsel is referring to with respect to the redesign, but unless it relates to that bullnose median, the fact that it's there, and the absence of a turning lane, it's irrelevant to this case. Now, there's been certain maintenance activities, Judge, we already talked about those. Paving, application of asphalt in the center of the median, filling in potholes, repainting lines. It may be that council is calling that a quote-unquote redesign of the intersection. It's not. Unless there was a change to the lanes, there was an addition, deletion of that island, there was some other traffic control voluntarily undertaken by the city, they didn't assume that responsibility. And that doesn't apply to this case. Remember, there's three elements: duty, breach, causation. The only thing that's been submitted in this case is causing that accident relative to the design is the absence of a turning lane. Okay.
Council, you should be mindful of your time, and I'm not taking off of your time, our little break in the action.
Thank you. One more quick issue, and then I'm going to conclude, and I'll rely on my briefing as to the other appellate arguments.
That's fine.
Council argues that 1621 is the seed of jurisdiction to the state with respect to the roadways, is discretionary, and therefore it doesn't apply, or may not apply, or it may permit dual jurisdiction over an intersection. My response to that is that that's not what the statute says. What the statute says in 1621 appears in Title 8 of the Vehicle and Traffic Law, and it's different articles that stake out the authority of different types of governmental bodies. There's a section for the state, there's a section for public authorities, for cities, for counties, for towns. What it says is, in the preamble, it stakes out the area of control of the state, and then it lists, it gives a laundry list of the types of regulation that the state can undertake within its given area. Now, the area that's staked out to the state highways, intersections with state highways, and those parts of roadways that intersect with state highways 100 feet from the intersection. That's the seed of authority to the state. If you look at all the corresponding sections for all the other types of government bodies, there's a carve-out. It's for the city, it's the roadways within the city, except for, under 1684, the areas maintained by the state. So what the Vehicle and Traffic Law does is it informs the common law. Council has argued that the Vehicle and Traffic Law violates the common law. It doesn't. Council misstates the common law. The common law is, this is from Lopez versus Rasta. It has long been established that a governmental body, be it the state, a county, or a municipality, is under a non-delegable duty to maintain its roads and highways in a reasonably safe condition. So what the common law says is whatever public roadway you have in the state, there will be a governmental body that has a non-delegable duty with respect to that roadway. And and the courts look to the vehicle and traffic law to inform who owns what roadway.
Mr. Powers?
Yes?
Here's what I'm stuck on, at least at the moment. In conducting our analysis of this appeal, from your perspective, must we include therein that section 1621A?
No.
Why not?
Well, as a preface to my answer, I would say you shouldn't exclude 1621. 1621 and 1681 are coextensive, as this court has held. Okay, but
I'm just stuck on 1621A right now.
Okay. So,
and what I thought you were going to say, and I would like to hear more from you, is part of your argument is that as a matter of law, under 1621A, the city had no control over this intersection. Did you hear my question?
well, there are a couple exceptions to that. Obviously, we talked about. So if you voluntarily assume a duty, you've got to perform that duty.
We're not there in this record.
Yeah.
And I don't want to mislead you. I mean, you probably know that I'm trying to quote directly from Costanza. That is, Costanza cites to 1621A. And
I didn't know that's where you were going, but I'm glad to address
that is where I'm going.
Okay.
And I'll give you a chance to answer, I promise.
Sure.
But if I thought you were going to say that you need for us to look at 1621A for you to prevail as a matter of law, and that therefore you would need for us to say that as a matter of law, the city did not control the intersection at all under 1621A. So I thought that's where you would need us to go. If you don't need us to go there, I need to know why not.
Okay. With reference to Costanza.
And that one sentence in Costanza that cites the 1621A, that is, I think, for your appeal, a sore thumb, respectfully.
Okay. So the decision in Costanza was that 1621 would not permit the county summary judgment. Application of 1621A to that case, to those factual circumstances, would not permit the county summary judgment. Okay. Plaintiff argues that that means that the county and the state can have the same duty under 1621A. That's not what the record shows us, though, because remember our two sources of liability. So even if the state has a control of the intersection over 1621A, the county's still in because they designed the intersection, they created it. That's in Justice Dillon's decision. It's
not in our decision, so.
It's in the record, though.
Understood, and the record forms the decision, and you were a good lawyer, you look at the record. But I'm stuck on the language that we use in Costanza and whether or not we need to do anything with it, so to speak. I don't know. If you need that, if that language in Costanza is an impediment to your appeal, and we, for whatever reason, are going to agree with you, assuming I agree to it, can we decide in your favor without doing something with what's in Costanza?
I have two more responses to that question, Judge. First of all, and I don't want to sound like a broken record, if you look back at Miller versus Tuckles, and that was a case where the trial court found that both the town of Arcade and the state could both share in the responsibility for the design of a state intersection. This court held under 1621A and 1681, both of them, that the state had exclusive jurisdiction, intersections, and 100 feet of the intersection, and that the town had no general duty. Okay, that is the law of this court. Okay, so second, my second point that goes to your question, this court already found that is a state intersection.
Yeah, I'm sorry to make you go over your arguments.
It already did.
Put it in my own.
In Lillian C. this summer, this is a state-controlled intersection. 1681 also applies. And that relates to traffic control devices in highways and state intersections and approaches to state intersections maintained by the state. This is a state intersection. One of the legs of this intersection is I-690 Einland.
Counsel, you should wrap up.
Thank you. In conclusion, I'll rely on our briefing, for all other points. But I would also observe that the correct application of the law in this case does not leave the plaintiffs without a remedy. If they're right that this intersection was negligently and defectively designed in 2015 and they can prove it, they will have a full remedy in the Court of Claims in the Lillian C. case versus the State of New York. And what we're asking the court to do is apply the law as it's set forth in all these decisions and grant the city summary judgment.
Thank you, Counsel.
May it please the court. My name is Steve Williams, and I represent the plaintiffs in this matter. So, my opponent likes to refer to this court's decision in the plaintiff's case against the state, where this court held.
Mr. Williams,
that,
I hate to do this. I'm going to tether you.
I'm sorry.
To the podium.
I do that every time. I'm sorry.
I know.
Can't help it. But in any event,
too much time in front of a jury.
Right. Where this court held that the state exercised some control over this intersection. And my opponent wants to use that to mean that the city, therefore, exercised no control over the intersection. But the issue of whether the city also exercised control over the intersection was not before this court in the case against the state. That issue was before Judge Lamondola. And Judge Lamondola held, based on the facts, the unequivocal, undisputed facts, that both the state and the city exercised control over this intersection and therefore had a responsibility to keep it safe. And that was based on the facts. Now, my opponent wants to say, well, this is a road design case. This is a road design case. It was designed by the state in 1974. How could that be the city's problem? That's not what this case is. This case is a failure to maintain these roadways in a safe manner in response to changing circumstances.
Which would require, would it not, Counsel, a redesign of this intersection? That's part of your claim here. It should have been redesigned.
Correct, Your Honor.
All right. And did the city have the ability to redesign this without the state imprimatur?
Excellent question, Your Honor, and the answer is unequivocally yes. How do I know that? How do I know that? Because the city did it, and it did it twice. After this road was designed in 1974, and just in the short years before this accident, the city changed the intersection. Now, my opponent wants to talk about maintenance and repainting lines. I understand that, but that's not what happened here. As this court knows, there was no turn lane for people traveling east on Burnett to see oncoming traffic. But they could still scoot over, as was noted in the emails between the state and the city. After that was aware to all, the city went in and built a raised concrete island in that area, which further discouraged drivers from scooting over to the left, thereby further precluding them from seeing oncoming traffic, which forced this co-defendant Lee to have to swerve to the right to be able to see behind the cars lined up across from her.
Mr. Williams, hang on a second. But your opponent says that's not anywhere in the record. It's only in your brief.
Well, he's just flat wrong. It's in the record. It's throughout the record.
Can you identify where that is in the record?
I can't as I stand here, Your Honor. I'm sorry. But that's an undisputed fact. It's in the record that they built this raised concrete island and painted double yellow lines around it. So we know that the city could do something without talking to the state because they did that. And then after this accident, the city claims that we have no control. And this is in the record as well, Your Honor. After the accident, the city went in and redesigned the intersection and included a turning lane where one should have been and got rid of the concrete island the city had built. The city did that on its own. So we know for certain that the city could take action to make this intersection safe because it took action without approval from the state on 2 occasions. And the first action it took didn't make it safer, it made it more dangerous. And that's the hook here. You see, because my opponent wants to cite all these cases that are very, very old that have been decided by this court. But I want to cite to the 2 most recent cases decided by this court. One is Costanzo, as Judge Curran has already raised, and as has Judge Greenwood. Costanzo is right on point. And in Costanzo, this court held that both the local municipality, in that case the county, and the state could have shared responsibility for that intersection, and this court refused to let the county out of the case, notwithstanding the county's reliance on Vehicle and Traffic Law 1621A. The court was not persuaded by that argument. What was the case just before that decided by this court on this issue? It was the Beaumont case. And in the Beaumont case, the municipal entity there, which was the town of Van Buren, not only relied on 1621A, it also relied on 1821, the two statutes cited by my opponent. And this court was not persuaded. This court did not let the town out. It held the town in, notwithstanding those two statutes. And one of the things that the court mentioned in its decision is, and you know, the town actually made this intersection more dangerous because the state had put up a sign saying stop ahead, and then the town put up a bridge abutment that kind of blocked the vision of that. So no, the town's in on this thing. That's identical to this case, where there was a lack of a turning lane, and the city came in and made it worse by creating a paved island, further discouraging drivers from moving over to the left to see oncoming traffic. Judge Lamondola analyzed the facts here very carefully. My opponent wants the law to be simple. He keeps arguing it's a binary decision. He's been saying that since we started this in 2016. But it's not simple. And the law is rarely simple. It's nuanced. And it's based on the facts. And Judge Lamondola painstakingly evaluated the facts and the evidence in the record to find that as a matter of law, the city and the state shared the control of this intersection. That's his finding. And there's nothing in this appeal or in their brief to overturn Judge Lamondola on that very well-founded decision. That is the law of this case. Now, the city's got a remedy. I mean, they've sued the state for contribution. They know that they control this thing with the state, and they've brought a claim against the state, and this will be hashed out. And the court of claims will decide who had more control and who should have done what. The city's not left without a recourse. They know that they controlled some of this intersection. That's why they sued for contribution. The facts are clear. Judge Lamondola, he painstakingly reviewed this very, very voluminous record. He wrote a very detailed, long decision. He cited Costanzo. He cited Beaumont. The latest, the most recent two decisions by this court on this very issue, and he said they shared the control for this intersection, and they both should have taken steps to make it safer for the public, because, as this court knows, it wasn't the original design of the intersection. I mean, it should have had a turning lane, and there's no explanation for why it didn't. Nobody's offered one. But it became dangerous with increased traffic flows. That's what the plaintiff's expert said. Plaintiff's expert didn't say it was defective as designed back in 1974, but the changing circumstances of more people living in the Eastwood neighborhood and gaining access to 690 through that intersection and the backups of traffic as evidenced by studies, traffic control studies, that were made known to the city and made known to the state before this accident, dictated that there should have been a change. It's not a road design case. It's a failure to keep the roads safe for the driving public. And they violated that duty. And they knew about this condition. Not only is that evidence through their emails, not only is it evidence through the traffic control studies they had, it's evidence because they testified they went through the intersection every day to check it out. It's evidence by the fact that they were there creating some kind of concrete island for no reason. They shared the control just like the state. They're both responsible.
We'll take a look at that, Counsel. Anything further?
Thank you, Your Honors. Appreciate your time.
Thank you. Case 921, Amirs New York LLC versus Brookstone 8 LLC. Both appearing by video.
Good afternoon, Your Honors.
Counsel, can you hear us both?
Yes, Your Honor.
Yes, very good. We can hear you. Very good. Please proceed.
Thank you, and may it please the court. Jeremy Schur for Appellant Emress. I will keep this argument relatively short because this court's extensive precedence on vacating default judgments, re-argument, and renewal, especially this year's decision in fusion funding, make this case relatively simple. The trial court correctly denied a motion to vacate where the defendant came forward with conclusory and, in one case, unsigned affidavits about non-receipt of process. There's extensive precedent supporting that decision. On re-argument and renewal, the trial court identified no legal error with its decision, yet granted re-argument anyway. And on renewal, yes.
In the original motion, in the first motion, didn't the defendant establish why they didn't receive it? Didn't the principal, Mr. Ingber, I believe, indicate that the reason they didn't receive it was a wrong address with the Secretary of State, offered that, and then also claimed that the attorney that received a courtesy copy was a former attorney, or I think prior attorney, were the words that he used in the affidavit, and also mentioned that he didn't receive the email, indicated that he had heard that there was an email sent, but he didn't receive it. So it was more than just a flat denial, I didn't get it. He went through some measures. Why is that insufficient? Under 317.
Yes, the statement that the address was wrong with the Secretary of State was only in an unsigned affidavit. That only came on reply. The statement about the lawyer is inaccurate because that same lawyer, Solomon Rubin, represented that he was Brookstone's counsel in a 6-page
November 22nd.
Yes, stating this matter is going to litigation. I represent Brookstone in regard to the same contract that's at issue in the lawsuit, and here are 5 pages of document preservation instructions.
So November 22nd, hold on, so just so I'm clear on the record, November 22nd, Mr. Rubin writes a letter indicating that he represents Brookstone with respect to the contract.
Same contract.
And then we have an affidavit from Mr. Ingber in February indicating that prior counsel, who was not authorized to receive it, the service on the behalf received a courtesy copy at the time the complaint was filed, which is around December 9th, 2021, a couple of weeks later.
Yes.
So that's what we had. That's the record.
Yes. And also,
so the judge is making an assumption that Mr. Rubin is litigation counsel and still retained 2 weeks later, but that's not really in the record, is it?
It is in the record, Your Honor, because Mr. Rubin stated that he was counsel regarding this issue, and this isn't a question of whether Mr. Rubin was authorized to accept service.
Where's it on the record? And I thought Mr. Rubin didn't do an affidavit the first time around, and that was part of it. So how do we know that he's still counsel on December 9th when they sent him a courtesy copy? How do we know that? Especially when we have a flat contradiction by Mr. Ingber in his February 14th, 2022 affidavit.
He was not litigation counsel. That's correct.
How do we know he's counsel at all? Mr. Ingber calls him prior counsel. Paragraph 5, page 39 of the record.
Because 1, he represented himself to be just a few weeks earlier. 2, when he got the process, he forwarded it to his. He forwarded it to Brookstone. He didn't say, "I don't represent this party. I'm not going to have anything to do with this." He simply forwarded it to Brookstone. And on the motions, when he did submit an affidavit later on the motion to re-argue and renew, he called Brookstone his longtime client. So
the evidence that he forwarded, again, Mr. Ingber's affidavit, page 40 of the record, I have been told the email was forwarded to me, but I did not receive it. That's all we have on the forwarding at that point, at that juncture, right?
That's correct. And it's at that juncture, it is Brookstone's burden to demonstrate that it lacked notice, right? Because we're talking about notice. If this were a garden variety case where a party was served via the Secretary of State and said, I never received the papers and here's why, then there are cases that would support such a defendant. But this is not that case because of the emailing of the papers to an attorney who held himself out as an attorney for this party and who admittedly sent the papers to the party. And then we have a one sentence, extremely, I don't even know the right word to say it. It begs a lot of questions just saying, I've been told I got this email, but I did not actually get it. But he did get it because later we know from the papers submitted on renewal and reargument that the email was actually received. It just was in a supposedly inaccessible folder for reasons that were never explained. So that's what takes this case out of the garden variety Secretary of State service case. And
Well,
that's
it's not about service. Service is okay.
exactly.
It's about
Notice.
receipt. Receipt is the key. The receipt and then meritorious defense is the key under CPLR 3017, right?
Yes, notice and meritorious defense.
All right,
Absolutely. So our argument is essentially that the combination of Solomon Rubin's letter, his admission, the admissions that Solomon Rubin once receiving the process forwarded it to his to Brookstone, which he held himself out to be his client, and the fact that the case law that the Supreme Court relied on, and which no one has ever disputed at the trial court level, holds that an attorney's awareness of litigation provides notice to the client.
Mr. Sure, Mr. Rubin is not only have noticed litigation, he's telling your client to be on notice of impending litigation to preserve records.
Exactly. He sent me the longest document hold notice I've ever received.
I'd like to take you, Mr. Scheer, to the renewal portion of the appeal. And as I read Supreme Court's decision, it did not grant renewal in the interest of justice.
Correct.
Rather purportedly on a reasonable justification for not submitting evidence on the first motion. What I can't find in the record, and maybe you can correct me or maybe Mr. Newman can correct me, I can't find in the record any allegation by anyone for the defendant that there was any reasonable justification for putting in that IT person's affidavit, and not until May. I mean, they could have, as I understand it, this is information in the defendant's own possession. This is something all they had to do is turn around and ask this person, just as they did 2 or 3 months later. They could have gotten this person to say, hey, the email's not there. They could have provided it. And I know there's some allegation of an emergency application, but the fact of the matter is you hadn't domesticated the judgment in New Jersey yet. Your subpoenas are probably worth maybe the postage at most of going there because they're out-of-state subpoenas. So there's really no emergency here. Can you cite to me in any event any allegation in the motion papers from the defendant where they allege that there was reasonable justification for not providing this information in their own possession sooner?
Aside from the unsworn arguments that you mentioned from the memorandum of law saying we were under some sort of emergency, there is a total of one sentence to that effect in the attorney, in an attorney affirmation, from counsel who did not represent Brookstone when it moved to vacate. And that just says in one sentence, there was an emergency. That's it. So
the motion to vacate was something that was of their own timing.
Exactly.
If it took, and they already waited 3 to 4 weeks before they made it, if they waited 1 or 2 more days to go ask this IT person, hey, would you look at my emails? This is information the defendant had exclusive control over. There's no discovery that needs to be done for the defendant to discover it. They have it. They just failed to look, and they didn't supply us any justification for failing to look. Am I close?
You're completely correct. And on top of that, it's not like Brookstone requested more time before the trial court and was told no. It even received a stay before the trial court. So there is no...
Counsel, let me ask a question along the lines that Justice Curran just asked, just so I understand this properly. The claim is that they never received the email, right? And the presumption that I read into that is that we all get emails. You got an email box, an inbox. They said that never came to the inbox. Could that be true? And also that they did receive the email in some kind of other folder, a spam folder, whatever the computers do to save you from searching for all kinds of emails that you don't want to look for? Could that have also happened?
Of course, Your Honor.
Okay. And so would that be something necessarily that we should charge them with searching everywhere on their email box for potential service in other forms, or should we just look at what's in the inbox?
I don't think Your Honor, the court even has to reach that issue. And I'll answer Your Honor's question. It should be whatever is received. But that shouldn't be this court's problem. So we're dealing with really a motion for re-argument and renewal, not the original motion to vacate. And that's not the right forum to bring up an argument that's so fact specific. The reason I'm saying this court doesn't have to reach it is because, as I mentioned earlier, the trial court cited cases saying that when counsel who are involved in a case, such as by sending a 6-page litigation hold notice, are aware of litigation, then their client can't say, well, we had no notice. And it's up to the lawyer and the client to make sure that the client is fully apprised. That's not the problem of the plaintiff. And no one, excuse me, I shouldn't say it that way. Brookstone never challenged that legal holding. So this is really a re-argument issue. Did the court make some sort of legal error in, did it misapprehend the law in denying the motion to vacate? And Brookstone never even argued that it did when it came to the concept that a lawyer's awareness of an action is notice for the purpose of CPLR 317. If we do go further than that, then we're looking at one sentence that Justice Noah quoted from the affidavit of Shlomo Ingber saying, I was told I received the email, but I did not. I did not actually receive it. And that's a conclusory statement that is essentially meaningless.
And Mr. Sure, the email that we're talking about, should we get to that point, is an email from the longtime counsel, Rubin,
yes,
top executive of the client.
Yes.
And I don't think they're saying in the IT persons that it never arrived. It arrived. Correct. It just somehow, some way, without any explanation, ended up in either a spam folder and got purged from the spam folder. But again, there was no justification for why they didn't ask that IT person to check Mr. Inger's email box like they ultimately did in May, right?
Yes, Your Honor. The explanation ultimately doesn't make sense for why the email was somehow hidden or invisible. But if the court wants to go that far, then that's the position that Emrys would take, that at no point has Brookstone ever offered a coherent explanation for why this email, which Your Honor is 100% correct. It is undisputed that Rubin sent the email to Brookstone containing all of the process. That's undisputed. It's never been explained why Brookstone couldn't see it. If we credit that one sentence conclusory statement in the motion to vacate as true.
Counsel, you should begin to wrap up.
Yes. I am not going to get to meritorious defense, even though we briefed the many reasons why one is not established, even if notice is established. Those reasons are extensive. And Your Honors, I would conclude by saying this is a fusion funding redux, as well as a repeat of many of this court's precedents going back to the 1998 case of Welch Foods, saying that a motion to renew is not a second chance to make up for a lack of due diligence on an earlier motion.
Thank you, Counsel. Counsel, proceed.
Good afternoon, and may it please the court. My name is Evan Newman, and I represent the respondent Brookstone 8 LLC. I think it's important before I answer what I'm sure the questions are from the panel, that the perspective of where we are now is an abuse of discretion scenario. We are in a case, and Mr. Scher likes to say this is squarely in a fusion funding scenario, but fusion funding said, like I'm about to say, that the decision on whether to deny or grant a motion to vacate is squarely within the discretion of the trial court. And in that case, in fusion funding, the court denied a motion to vacate, and therefore this court refused to analyze, although actually the court did analyze the evidence in its decision, but stated that it would not analyze the evidence or the reasoning behind that decision because it's squarely in the discretion of the trial court. Here too, while we can go back and forth and decide whether or not these claims are believable or conclusory, the point is that on the record, every element necessary on any of the 4 or 5 motions that are before Your Honors today, there was sufficient evidence to support any of those elements, and it was well within the court's discretion to decide whether or not to vacate the default judgment. And therefore, at this point, it's really an abuse of discretion. It's not a why didn't they, or could they have, or did he really? It's really just a question of, is the evidence there, and did the trial court abuse its discretion? Another thing.
But Mr. Newman, to follow up on Justice Curran's questions, you know, what prevented your client from basically making the exact same proffer that it made on the motion to renew and re-argue? What prevented your client from doing that in the very first instance? And if the answer is nothing, then why wouldn't it be an abuse of discretion?
Well, nothing prevented them other than that they were prior counsel was following the precedent in this court and in this state, that the elements necessary to vacate a default judgment were the lack of any notice. And there was sufficient evidence in the original motion to show under 317 that there was no notice. There was no notice. My client swore he did not know about it. He swore he did not get an email. What other evidence in the world do you need? The corroborating evidence of all these third parties is honestly unnecessary. It's extra. So my client did not, you know, because you had information subpoenas, you had a foreign judgment being sought. He decided, which is stated in his affidavit, that he moved fast. He moved fast. We're all Monday morning quarterbacking and say he could have done this better. You're right. Everybody could have done a better motion. And you're right. The second motion was better, right? But under precedent, there was absolutely no need to make a gold standard Rolls-Royce motion on an emergency basis. They were acting under exigent circumstances.
I recall now that there were information subpoenas. I know that was an issue. There was a motion to quash also brought as part of that. How did that create the sense of urgency? Explain that to me.
There's nothing in the record to explain why they felt it was urgent, but they filed this motion very, very quickly, Your Honor. If you go to the timeline, the original motion was filed
February 14th. I know, we've got that, but
they moved quickly, and all these affidavits are in the hands of third parties, and they determined that they were going to move quickly because of the information subpoenas. I have no idea why, and there's no explanation. But again, also it's important to note that the court below did not really find a reasonable justification. It actually more followed the precedent that on a motion to renew, right, it's not fatal because of substantive fairness. So they actually really I think it was more of a focus on substantive fairness, and also to keep in mind that on re-argument, the court denied the motion to vacate and allowed leave to renew. So for those two reasons, the court was correct in considering all this additional evidence. First, because on re-argument, the court granted leave to renew. And second of all, because under substantive fairness, the court felt it was right to consider that. And the court explicitly said that. And therefore, the reasonable justification, I mean, I agree. We can, Monday morning quarterback, I would have wanted another 2 weeks to get a much more affidavits. Of course, especially now that I see what the affidavits say, and they're also clear. Of course, I would want to do that. But at the time, I have no idea why they decided not to. They felt there were exigent circumstances. I certainly don't know what the feeling of having information subpoenas on $1 million judgment feels like against me. I know from the people that call my office upset when I send them that they're probably not a good feeling. And therefore, they move quickly. But again, it's important to bear in mind exactly what the standards are here are, because there was a lot of talk about whether he did or didn't get the notice. He swore he never saw it. He swore he never got it. He swore he never sent the email. The IT person swore that the third party swore that my client was never able to see the email. The attorney swore he was never retained and that he was not authorized to accept service. And again, Mr. Chair says it's the precedent of the court, but it's important to read these cases to really understand the court case about attorney authority in Born to Build is an extremely distinguishable scenario. First of all, there was a motion for alternate service. Second of all, the court found that the attorney, it was a Chinese resident, I don't know if it was a Chinese national, but the defendant was living in China at the time. But at that point in the litigation, both the attorney and the defendant had participated extensively in the lawsuit. And therefore, the court found that alternate service under 308 was authorized because the attorney clearly had authority to act on behalf of the defendant because she was literally there acting on behalf of the defendant. That's wildly different than a motion to vacate standard to say that Mr. Rubin clearly had authority because he had sent months earlier or weeks earlier a litigation hold letter.
Any further, counsel?
No, thank you, Your Honors.
Thank you. All right, the last case on for argument is Renew 81 for All versus New York State Department of Transportation. Counsel, proceed when you're ready.
Good afternoon, Your Honors. May it please the Court, I'm Meredith Lee Clark from the Attorney General's Office on behalf of the Department of Transportation. Your Honors, over the past decade, the Department of Transportation has worked with the community in Syracuse to reimagine and reconfigure the dilapidated and dangerous I-81 viaduct. The extensive administrative record before this Court demonstrates that the Department's environmental review met all of its legal obligations, including those imposed by both SECRA and New York's climate law. The Supreme Court erred in granting relief in the nature of mandamus to order the department to prepare a supplemental environmental impact statement to account for the announcement of the Micron microchip manufacturing facility, and separately by annulling the department's already completed EIS based on the department's purported failure to take a hard look at the project's air quality and stormwater impacts. I'd like to turn first to the issue of the supplemental EIS. Supreme Court erred for two reasons. First, mandamus is only available where there is a clear legal right to the relief, and petitioners have not demonstrated that. Second, whether to prepare a supplemental EIS
That's a discretionary call, isn't it?
That's correct, Your Honor.
So it's not, they're not compelled to do that.
That's correct.
So that's why you argue this falls outside of the mandamus area.
Absolutely. And courts, as explained by the Court of Appeals in matter of Bronx Committee, will defer to any reasonable judgment by the agency whether to prepare a supplemental EIS. And here the department has taken the only reasonable judgment, which is to decline for now to prepare a supplemental EIS because there is simply no data available on any impacts from the Micron facility. No one disputes that Micron is a major, potentially transformative project, but it will undergo its own rigorous environmental review that will have to take into account I-81 and the reconfigured transportation system in Syracuse.
And as you mentioned, the Department of Transportation hasn't ruled out the possibility of a supplementary.
Absolutely. It could certainly, if such data becomes available, it could certainly choose to do so. But again, that's a discretionary decision. If petitioner's argument is correct that all work should stop until such data becomes available and the department in its discretion perhaps decides to prepare a supplemental EIS, the state would be required to stop all work on all projects that could potentially be affected by the Micron facility. This would have a huge impact on central New York and the greater region. New Yorkers could be forced to travel on outdated roads and bridges. And the I-81 project, in contrast with the Micron project, is a fully developed project that underwent over a decade's worth of review, and construction has begun with very real costs for each day that completion is delayed. We explained this in our opposition to petitioner's motion for a stay earlier this summer. And department experts estimate that it's perhaps upwards of $25,000 a day that the public incurs for each day that construction completion is delayed for all of the delayed benefits. I'd also like to talk briefly about the fact that the record demonstrates that the department took a hard look at the potential environmental impacts. Supreme Court looked at or quibbled with the department's analysis on two grounds: for one, air quality, and second, stormwater.
Let me stop for a second, counsel. What was the Supreme Court supposed to do if they determined that the lead agency, your agency, did not take a hard look?
So if the case law makes clear that the whole EIS is annulled.
Right. And that's not what happened here, though, right? The Supreme Court took a couple of items and they said, you know, I don't think you did the proper job in air quality. I don't think you did a proper job in the other. And, but that's not the role of Supreme Court in this case, in terms of reviewing these. And so if the Supreme Court didn't make the conclusion that you failed to take a hard look, where does that leave us?
So that's an issue of, I believe that issue is academic because the record demonstrates that the department did take a good look, took a hard look. And we argued this again in our motion papers this summer that effectively what Supreme Court did was put in place an affirmative injunction, recognizing that regardless of what the court ordered, the parties were going to appeal. And so in order to keep the project moving and recognizing the costs to the Syracuse community, Supreme Court effectively put in place an affirmative injunction allowing limited construction of the project. But the propriety of that is really academic, Your Honor, because the 84,000-page record demonstrates that the department did take a hard look, including as to air quality impacts and stormwater. Section 6-4-4 of the EIS demonstrates that as well as Appendix G of the EIS, demonstrates that the department took a hard look at air quality throughout the region, including on the current 481. There would be no increase under the selected alternative in proportional diesel traffic on 481, which is what generates high levels of air pollutants. The community grid alternative makes the regional traffic flow more efficient by creating new exits and renovating and improving exits on the current 481, as well as dispersing traffic throughout the downtown area. This means that there are no more bottlenecks, there are no more congestion points, which the department experts rationally concluded would not only improve air quality on 481, but also downtown and region-wide. Likewise, the department concluded rationally that the project would actually improve stormwater conditions in Syracuse. This conclusion is that there's an extensive examination in Chapter 5 of the EIS, specifically at page 2444. The department talks about that that the community grid alternative will improve water quality in Onondaga Creek and Onondaga Lake. And it was reasonable for the department to anticipate compliance with applicable regulations regarding stormwater pollution plans that will be developed, that necessarily will be developed for site-specific areas as construction and design continue. Likewise, the department complied with all of seeker's procedural requirements. The standard that the Court of Appeals has laid out in Village of Westbury is that the department's regulations must be applied in a manner no less environmentally protective than DEC's general seeker regulations. Village of Westbury did not invalidate the department's seeker regulations. In that case, the agency had not prepared an EIS citing that it didn't have to under the department's regulations, even though the project would have required one under DEC's general regulations. And so the court ordered the department to go back and prepare an EIS. Here, this is completely different. The 84,000 plus pages of the department's record demonstrates that its review was extremely environmentally protective. I will refer to my brief for the majority of the rest of the various areas that the department examined, but I'd like to talk briefly about the New York climate law, the CLCPA.
Counsel, before you get there, you talked about the evaluation with respect to the diesel traffic, but what about the environmental impact on the increase in the traffic, the regular automobile traffic? Was a hard look taken at that?
Absolutely, Your Honor. So the project not only, I believe Your Honor is referring to traffic in the downtown area, is that correct?
That's correct.
So currently the department's analysis shows that diesel traffic that is on the current I-81 viaduct starts and ends primarily downtown. And the way that the I-81 viaduct is constructed right now, it has very minimal access points and short turning or exit lanes. And so you get these bottlenecks and congestion. And what the community grid alternative does is disperse this. And so disperse traffic and create significantly more, a greater number of access and entrance points. The department's analysts took a hard look, not only at 481, as I mentioned earlier, but also the impacts downtown. It looked in particular, petitioners complain in particular about carbon monoxide levels. And the department took a extremely hard look at these issues, prompted by not only its seeker obligations, but also concerns from local residents. The record shows that under one of the other final alternatives, the viaduct alternative, the anticipated carbon monoxide levels were were higher than the anticipated levels for the community grid alternative. And so the department conducted a micro-scale analysis of carbon monoxide. For the community grid alternative, these anticipated levels didn't even reach the triggering threshold for such a study. So based on that, the department rationally concluded that the community grid alternative would actually improve levels of carbon monoxide and particulate matter throughout downtown. Does that address your?
Yes, it does. It does.
Counselor, the petitioners didn't put in any expert testimony of their own on these issues, did they?
No, Your Honor, and such testimony would have been inappropriate because this is in Article 78, Your Honor.
Well, I'm talking about when the original analysis was done.
Okay. Sorry.
Right. There were no expert studies at that stage that the court could have relied on previously.
That petitioners put on, Your Honor? I'm sorry, I misunderstood.
Yes.
No, as far as I understand, no. And there are no such studies in the record. What's in the record is...
Right, because typically what you have in local government is when someone's opposed to some traffic redesign, that they come up with their own traffic engineer, their own environmental studies, that type of thing. And that didn't happen here, correct?
That's correct, Your Honor. And petitioners did, or certain members of petitioners certainly commented throughout the extensive public comment process. But so the studies and the data that's in the record are data that the department both collected and analyzed, and that data supports the department's conclusion that the community grid alternative would not adversely affect the air quality downtown or throughout the region.
Thank you.
Thank you, Your Honor. Lastly, turning to the climate law, the project, this is in chapter 6-4-5 of the EIS. The project will actually decrease greenhouse gas emissions region-wide. There is no data supporting petitioners' argument that the project will somehow increase greenhouse gases outside the project area.
So what data are you relying on to say that it will decrease?
The data that's in the EIS that the vehicle miles traveled will decrease by region-wide by 4 million miles. and improved infrastructure. This all leads to the department's rational conclusion that the greenhouse gases within the project study area would actually decrease relatively quickly once the project is completed. I think one of the things that this touches on is petitioner's argument that it will somehow increase truck traffic outside of Syracuse. There's likewise no data that supports that. The department's engineers did extensive traffic modeling and found that there would be no diversion of traffic onto, say, State Route 20, but rather that through traffic will simply stay on the interstate. Likewise, the project does not change any local or municipal laws as to the grades of trucks or the load limit, the weight limits of trucks on city streets. That will all remain the same. So the concern that this will somehow shunt traffic onto small village roadways just doesn't have any basis in the data.
No, but it is correct. It is correct that the traffic will be diverted to 481. Correct. I mean, that will become 81, but it's now 481.
That's correct, Your Honor. And 481 is currently being under Supreme Court's affirmative injunction is being improved to both to be expanded in terms of numbers of lanes, and then also with the improved exits and on-ramps to accommodate that increased traffic. And this actually will make traffic throughout the Syracuse region significantly more efficient than what is currently there.
You should wrap up, Counsel.
Thank you, Your Honor. So in conclusion, the extensive administrative record demonstrates that the department complied with all of its legal obligations. It provided ample opportunities for the community to participate, including petitioners, and it rationally selected the community grid alternative as the final alternative for the I-81 project. Thank you, Your Honors.
Thank you, Counsel.
May it please the court. Good afternoon. I'm Alan Knopf for the petitioners. Hopefully my voice will hold out. The court below correctly required a supplemental EIS for because of the Micron project that would transform the community, and it really needs to be taken into account before the road system is changed irreversibly. And obviously the remedy for this and for other defects are to...
How do we get around the idea that this is a discretionary call by the lead agency as to whether or not a supplementary is needed? And in this case, they chose not to do it at this time.
Well, Your Honor, first of all, they didn't choose, they never made...
It doesn't fall into the nature of mandamus unless it's a non-discretionary call.
Your Honor, first of all, they didn't make a decision. They refused to make a decision. We can only glean from their briefing that that's their position, but there was no decision. And that's what happened in the Bronx Committee case. And the Court of Appeals said, this is too important an issue. You've got to address it through a supplemental EIS, and there's no decision to defer to. So that's what the Court of Appeals said. And the Glenn Head case said the agencies have a continuing duty to evaluate new information. And here, the governor, Senator Schumer, all compared this to the Erie Canal. Well, we all know if you did the Erie Canal, you'd have to do an EIS.
But the Department of Transportation has taken the position that they may very well need to do a supplemental on this. They recognize that. But that right now, the information before them are press releases and that kind of thing, and there's not enough information for them to be able to do a substantive supplementary. How is that not true?
Well, first of all, there is a lot of information. In fact, they're going through doing a supplemental EIS on the Micron project. Secondly, an EIS is all estimates into future conditions. They had to estimate the traffic in 2060. Well, how do you, no one knows what the traffic in 2060 is going to be. SECA requires any reasonably likely Oh, sorry.
Continue.
Seeker requires not certainty, but whether environmental impacts can be reasonably anticipated.
And that's really the question before us, right?
Right.
Yeah, I mean, did DOT have enough information before them?
Or do they today? I mean, today.
To determine, well, what was before the court below is what we're looking at.
Right.
Right? That's the record before us. And so did they have enough information at that point to choose to exercise their discretion to do a supplementary?
Yes, Your Honor, because first of all, the governor said it's coming. So the governor is the head of their, above their agency. She said it's coming. They said there's going to be 50,000 new employees, et cetera, transformative for the whole community. It's like saying, oh, Rochester Kodak's coming here all at once. Huge transformative project, so they know that. Do they know all the facts and figures? No, that's the point of an EIS, to figure that out. So you've got to go and say, and do the investigation, do the study, and figure out how, what's the facility going to be like, what traffic patterns.
Counsel, let me ask you this. The court below indicated, I think in the decision, that a hard look wasn't taken at specifically two things, right? The air quality and the water quality, right?
Right.
And if the court determines in that posture that they didn't take a hard look, isn't their only option to annul?
Yes, that's the only option.
The court didn't annul here.
Right, and that's why we cross-appealed, because they did not have that. That is not an option. Literal compliance, if you fail to comply with seeker, you're back, you got to start all over. It's black letter law, no question. But in any event, on Micron, just like the Court of Appeals said, it's too important. In the problem, they argued, well, and the Micron EAS, they could have reviewed it. Well, Micron can't change I-81. So if they tear down all the ramps, get rid of the viaduct, and by the way, we're not saying they shouldn't replace the viaduct. We agree. Something's got to be done. The community's been working on this for more than a decade. There's no question something has to be done. Just the community grid, we believe it will be a disaster, throwing traffic into downtown, and frankly, we represent the South Side neighborhood, the environmental justice community. They're going to have to shoulder all this traffic. You're going to have to go through there. It's going to be stop and go traffic, and they didn't look at traffic safety, the air impacts. They only did the air study on carbon monoxide in downtown. As Judge Neary found, they didn't do 481, but they also didn't do the South Side community.
But Counselor, that's not our province, is it? I mean, we're not. That's a political management decision whether this is a good idea or not. We're just looking at whether annulling the seeker was and he didn't. The lower court didn't do that. So you agree that order was inappropriate, correct?
Yes, the relief was inappropriate because he had to annul it.
And what about the relief about not tearing down the bridge? Is that appropriate?
I'm sorry, I don't know which bridge.
Not tearing down the viaduct. I think that's a clause in the order.
Oh yeah, that was appropriate. He just didn't go far enough. He only partially annulled the determination. He should have completely annulled it. That's the problem. He did not totally annul the decision. And he didn't really have discretion to do that once he determined there was a seeker violation. If I could now address the greenhouse gas issue, and I think that may be the biggest substantive defect here. They did all these facts and figures. It doesn't make any sense that you're going to divert traffic 12 to 14 miles around 41 or put 40,000 cars into stop and go traffic, and it's not going to be any different for greenhouse gases. But even if that was right, they have admitted, and Ms. E. Clark admitted an oral argument below, there's a dramatic, the reason those numbers came out like that is, and I'm quoting her argument, there is a dramatic decrease in traffic from the south, and so I mean almost half. So that accounts for a dramatic decrease in any air quality impacts, unquote. So in other words, traffic coming from the south, and also when it goes in the opposite direction, is not going to go into Syracuse because they don't want to deal with the community grid. If you're headed to Seneca Falls, to the landfill, or to Rochester, you're going to get
Your
off.
opponent takes issue with that quote, saying you're taking it out of context.
I'm not taking it out of context. That was the context of the question. And I then went to the EIS and said, well, how did they do this study? And it's in our brief, the diagram, it shows you they only looked at the study area. And her argument was there's no increase in greenhouse gases in the study area. Well, we're talking about the whole world, the atmosphere. So Syracuse doesn't have its own private atmosphere. If there's people are diverted to go through Skinny Atlas or through the west side suburbs, it didn't even account for the south side neighborhood. When you look at that map, the streets that they considered. So what they did was say, well, all this traffic is gonna not go through the study area, so it didn't go into our calculations. So it's totally defective. It is not a proper analysis under seeker because they're not looking at the environmental impacts because the greenhouse gases are still going to be generated, go into the same atmosphere, but they're not included in their calculation.
We'll take a look at that. Anything further, Counsel?
Just the substantive, I just want to get to the substantive point. There's a lot in our brief. Obviously, I'm not going to go over it all. But seeker has a substantive requirement. And you look at the alternatives and determine what is what's going to mitigate or avoid environmental impacts. And frankly, the 1980 Marketplace Mall case from this court, I know none of you were on the panel, said that there is a substantive requirement. And you've got to mitigate. Well, what they did was, this DOT had certain project parameters, and you can't, if you violated any one of their project objectives, they threw out the alternative. So there was no sensitivity analysis. So they said, I gave the example of, oh, you're going to cut off Genesee Street for a block. Oh, throw that option out, because then we can't do a tunnel. Like, by the way, they're doing in Buffalo. In Buffalo, I note in my, responded to the Civil Liberties Union, in Buffalo, the Kensington, they're doing exactly what we're calling for to avoid all these impacts, because they're going to do a tunnel and have a community grid. We're saying do a hybrid solution, but they didn't look at those things. And by saying if you fail to meet one of our criteria, we throw out that option, and that is contrary to seeker. Seeker has a substantive mandate. You can't just say, oh, you missed one thing. And in fact, I said they honored it in the breach. At the very end, they put in they were discontinuing Martin Luther King East. They threw that in at the end without proper review in the FEIS, but they violated their own criteria. But you've got to have some ability to make adjustments in order to mitigate environmental impacts.
You should wrap up, Counsel.
All right. Thank you, and I just did a lot there. So in the segmentation was a big issue with the contaminated sites.
We'll take a look at that. That's in your
and all
brief.
that. So thank you very much. And we think that there are numerous defects, and they should be sent back to the drawing board, especially in light of, so we don't make a huge mistake for this community with Micron coming and have a road system that can't handle it and can't get people to work. Thank you.
Thank you, Counsel.